the 20 questions you're going to ask in my ideal world. Yeah, right. Okay. Yeah, well, okay. I get to create my
own. You brought a little, comedic.
I got my own hypotheticals, right?
Yeah, that's great.
My own scenarios, my own hypotheticals. If there was a beautiful stipulation what was clearly done, then that would be a whole different thing. But every time I ask a question, I get a not exactly, not this, but this is a caveat for this, and this is a caveat for that. This is what we meant here and there. And I appreciate good lawyering, but the point is, if you can't give me clarity, I have to give you some deadlines, and then we'll see what we've got at that juncture. So we are moving past depot designations. Folks, we are going to the calendar call portion of today's motion hearing. With regard to the calendar call portion, let's walk through straight EDCR 2.67 through 2.69. We understand it, starting first with exhibits, we understand that you all had a validation at 10 a.m. today. Did you all pass?
I'm sorry, did you say did we all pass?
The exhibits, yes. Did it pass
Yes.
validation? Didn't pass the first couple of times.
Yes, Your Honor, they are submitting, so to answer your question, no, they did not pass. They're going back at 3 o'clock because they had tried to validate with the USB stick. Apparently, that's not permitted. We did not know that till this morning. And now they want us to submit it via a hard drive, and it's being given to them.
But it's
a
in
hard
the
drive to be
rules.
validated at 3 o'clock this afternoon.
Okay.
We are just following what the IT department is telling us to do. So in 10 minutes, hopefully we will pass.
So should I stay tuned on that and go to other things and come back to exhibits after 3 o'clock?
Yeah, hopefully they will email us and let us know that it passed. But their appointment is at 3 o'clock today. They had an early appointment at 9 a.m. or something like that.
10 a.m. That's what I had understood.
Yes, Your Honor. Plaintiffs' exhibits have been submitted and they passed. They've been lodged as of the 10 o'clock appointment.
ETT, yours?
Ours are in the same boat as Mr. Odou's. Ours are going on for another test at 3 o'clock.
Okay. There's electronic protocols in place for you. Okay. Okay. Stay tuned. So, let's go to your nice little binder. Okay. All claims, you have your brief statement of the facts, your claims, relief, and affirmative defenses. I'm going to segue for a quick moment because the reason why I'm segueing is there's two motions that show that they are set for hearing after your trial the first day of your trial set to commence. Just 1 second. Okay. So I need to know, are the parties still wishing the court to prepare for a motion to bifurcate and a motion to strike? Counsel ETT, those are your motions.
No, Your Honor. We served withdrawals, or I believe we filed withdrawals.
But then we got an OST on the bifurcation after you told me in open court you were withdrawing certain things. And then we returned it because it didn't comply with the EDCR, but then we didn't.
The last I saw, we filed withdrawals of those, both of those. The motion to strike.
So the motion to strike currently set for 116, the stipulation between Rule of Order defendants and plaintiffs, document 989, you're withdrawing, is that correct?
That's not my stipulation, Your Honor. I think that's...
It says defendant ETT. Oops. 1 second, please.
The stipulation on liability and causation?
No, your motion to strike their stipulation.
Oh, no, we're withdrawing the motion, yes. The stipulation is not ours.
Yeah, no, I understand the stipulation's not yours, that was court ruling, but, okay. I'm just, that motion to strike is withdrawn, we vacated from the 116 hearing. The motion to bifurcate was also filed, but then we got an OST after the hearing on the 27th, so it wasn't clear whether you wanted this still left on. We returned the OST because it didn't comply with the rules, EDCR. But is the motion to bifurcate still to be heard or not?
No, Your Honor, that's withdrawn as well.
Okay, motion to bifurcate withdrawn in open court as well, to the extent it wasn't previously withdrawn. So that 116 is also going off. Okay, so then we're there at jury trial for 116. Since it's our panel, okay, I'm gonna deal with your calendar call motions, then calendar call issues, and then go back to the trial to see how many jurors you want. I can understand today's your last day to finish off your stipulations, and we'll walk through that in just a moment. But let's walk through the other stuff I just needed from the clerk to make sure we were clearing calendars on things we didn't need to address. Okay, so you have all your claims abandoned, etc. At this juncture, let's walk the format of trial, which is why I asked the question on the striking and the bifurcation. How is this intended to be with this three parties case? Is it counsel for plaintiff, you're going to do your case in chief, and then I'm gonna need to know real water, you going second, and ETT third, ETT second, and you third. How are you planning on doing this? Let's see what you all want to do. Counsel for plaintiff, go ahead, please.
Judge, I thought we would go first, and real water, I would think would go second since they're the manufacturer, and Table Herbst would go third. But I don't really have a position on second and third, but I would think that would be the logical way to do it.
Real water agrees.
Counsel.
And we agree, Your Honor.
Table Herbst agrees as well? Okay. So, then with regards to witnesses, we're keeping that same order of witnesses, is that correct? I mean, if somebody's calling the plaintiff's case in chief, plaintiff will go first for direct examination, then cross-examination of real water, then cross-examination of Terrible Herbst, is that correct?
That is correct.
Okay. Is there an agreement at all for witnesses out of order, or witnesses to be utilized for all purposes so that you don't have outside the scope type objections? Is there anything like that the court needs to be addressed? I did not see that specifically mentioned in your memo, that's why I'm asking.
No, Your Honor, but we're sensitive to people's schedule, and we've had a good relationship with Mr. Odou about moving things in and out if need be. For example, in the last trial, he had some witness that needed to go before we rested, and we agreed to it. And we anticipated we'd be doing that again.
And we appreciate that.
Does that work for you?
Yes, Your Honor.
Does that work for ETT?
Yes, Your Honor.
Okay, because you know the court needs to know, not saying I'm gonna get any, if there's certain potential motions that people may be filing, I just need to know what I'm taking into account, if any said motions, but we'll address that if any said motions, okay?
Yes, Your Honor.
Outside this, are any witnesses, are all of the witnesses being, appear through deposition being exhausted during plaintiff's case in chief, or sections of them going to be played / read, however you all decide what you're going to do, during the, either or both of the defense's cases in chief, etc.? Meaning, is the witness gonna be exhausted one time or appear multiple times?
Your Honor, I would think that the one witness that may be split up would be Blaine Jones, because that's what happened last time. We played a relatively small portion of it in our case in chief, and they played a longer portion of it in their case. So other than Blaine Jones, I can't foresee anybody that would be split at this point.
Your Honor, Joul will do for real water, we agree. In addition, if there were a punitive damages phase, we would play excerpt from Brent Jones. We would anticipate there'd be a discussion and objection of that, so, but that's a problem for a different time.
Okay, thanks for future. I'm just trying to go from a, witnesses are basically gonna be exhausted, correct?
That's the plan, that's the hopeful plan, yes.
Okay. Counselor ET&T, are you on the same plan, or do you have a different plan? Is there a difference?
I think most of them will be exhausted. I mean, to the extent we're calling the same ones.
Where we're really going is outside the scope kind of objections, meaning, for example, I want to take a witness that gets called in the plaintiff's case in chief. I'll take two examples. One, if it's by deposition, are all the deposition excerpts going to be read, video, whichever way it's going, in plaintiff's case in chief, or is it going to be maybe page 18 lines, hypothetically picking pages, page 18 is line 1 through 9 during plaintiff's, page 18 lines 15 to 22 during one of the defendants, or is it all going to be played together, or is that still up for grabs?
Judge, with the exception of Blaine Jones, I think they're all to be played together.
Okay, and live witnesses exhausted for no outside the scope, or is that by agreement of the parties at the time? I'll find out.
The only two exceptions I would have would be the two primary Terrible Herbst witnesses. I don't know what they intend on doing in their case in chief, so I don't know that I would want to hold counsel to putting her case in chief in during our case.
Okay.
So those are the only two I would think would be a problem.
Counsel for Water?
Yeah, we agree.
Counsel for Herbst?
I agree, Your Honor.
Okay, so there's nothing you need, okay, just if there's something you need to address, okay. Covers witnesses, any disabilities that the court needs to accommodate more than glad under state and federal law? Is there any witnesses that are coming in live that parties are aware of that we need to do any structural changes, hearing assisted devices, footstools, anything like that for any of your clients and or witnesses?
Your Honor, Mrs. Brody is older, but I don't think she has any disabilities other than typically people of her sector.
Meaning, can she get to the witness step?
She
and
can
step
get to the witness stand, Your Honor.
with a couple steps? Okay.
Yes.
You understand what I'm saying?
She
Do
may
we need
to be
ramps? Do
helped
we
up,
need,
but,
huh?
yeah, she may need to be helped up,
Okay.
but
No
other than
worries.
that.
If we had anybody with wheelchair, you know what I mean, any mobility issues, hearing assisted issues, anything like that, heads up is better in advance because obviously you see that there's not a ramp currently in this courtroom, but nobody needs anything like that. Is that correct, counsel for plaintiff? Counsel-
Yes, Your Honor.
Counsel for real water, how about yours?
Yeah, we would agree, Your Honor. I guess the only thing unknown is currently the status of Mr. Marlowe and his physical condition. He was very, very frail last time, and
Mr.
Yeah,
Marlowe,
that
who
would
doesn't
be-
get cautioned on to what to say, Mr. Marlowe, right?
Yes,
The
Your Honor.
inventor, Mr. Marlowe of the Russians, okay.
Yes, Your Honor.
We have served Mr. Marlowe a subpoena, with some communication with the office, with our office, and we expect him to appear.
Okay,
He's old, but he's
okay,
a pretty tough old bird, I would say.
okay. Where I just was going, you know what I mean, presumably the courtroom layout meets everybody's needs, is that correct? Does anyone need any special accommodations?
No.
Counsel for Herbst?
No, Your Honor.
No, you don't need any special
No,
accommodations?
we don't need any special accommodations
Okay.
for any witnesses.
Because that's outside, that's other people, I mean, we've got some standard little steps, you know, footstools for people with back issues and stuff like that, okay. Jurors, you all, let's walk through jurors before I get to some of the other stuff. Jurors,
Yeah, I'm waiting.
you all were getting your final stip list to us to get to Mariah today, is my recollection, is the last day for the December 18th group?
Yes, Your Honor, my understanding is that there was,
4 boxes.
I believe those were completed. I think there's just a last cluster that we're working on getting by today.
Okay. So we need to slow that one down?
Your Honor, Joel Odou for Real Water. I believe there's 260 questionnaires that were, for lack of a better word, late in the process, and we're going through those, and I believe the email was that we needed to have those done by the 9th. I can pull the email up and double check it, but I do know it's 260.
Oh, I believe it's the 8th, Your Honor.
Okay.
Or the 8th.
Yeah.
I stand corrected.
Remember the original chronology was
Yes.
today, but then we had the late ones, okay, so you all wanted the 8th, that's fine, okay. That's for the jury services issue, not my issue. Okay, do you all have a ballpark total of how many people you're gonna have remaining for purposes of potentially calling in, and then we're gonna see how many you want a day? Because I think, Mr. Kemp,
Yeah,
you
if I
said
can
you were,
answer part of it.
you were suggesting 4 alternates, right? 8 seated jurors, 4 alternates, so a total of 12, or Mr. Parker, whichever?
Yeah, Mr. Parker.
Your Honor, that's what worked last time. We ultimately did not have to use a single alternate. So eventually we ended with 12. But my thought is, Your Honor, given the capacity available here, 60 a day would be, I think would be great. I think you have 60 when you, more than 60 when you consider your box and then the space, the seats behind us.
Yeah, we've got an exact,
I counted them, you know, a few weeks ago, Your Honor. I don't remember the exact number.
Right.
I did a count. I think it was 59 in the
Okay.
gallery, and then obviously 20, I think 27.
Marshall, can you make this? One of my chambers on the little chair. You can't find it, don't worry about it, okay. So you need approximately, somewhere between 50 and 60.
Yeah, you
get
got
up to
20.
60.
You got 24 between the box and right outside the box, and I believe my last count was 59 in the back, Your Honor. I'm not.
Okay. Right, because what we would normally So you want 4 alternates, is that correct?
Yeah, I
Joel
think
as
that
well?
worked the last time.
Okay. 4 alternates, real water?
That's fine, Your Honor.
Yes, Your Honor.
Okay, somebody wants something different, okay. So then you're correct, and normally if there's, you do 12, normally we box double what you want, so if we can fit it in, which means
Right.
24, which is why we normally put 24 here, left gallery, right gallery. Is it, remember, and then your tables are for your council and your staffing people. If you're planning on having any staffing people sitting in any of those chairs, that's gonna present a challenge for, obviously, you know what I mean? A chair
Yeah.
versus a chair. Is anyone planning on having anybody here in person that you're
John?
gonna need a seat for? That's
On
other
be-
than your council tables?
Right, on behalf of the plaintiffs, Your Honor, we did not use a jury consultant in the courtroom, so you're looking at our group, other than our clients showing up at times.
Okay, but for during jury deliberations, you don't need a gallery seat for anybody, is that correct?
No, we won't need a gallery seat for a jury consultant during the voir dire process.
Anybody, I'm going in the global, anyone. The reason why I say what we normally, just to let you know, what we normally do is if people are gonna have anybody here to view, we take away a whole row from potential jurors. We do not mix viewing
So-
people with potential jurors, okay?
So
So
we
we
did-
reserve either the whole last row
Okay,
or half a last row, depends on if parties really wanna have them on each side, right? Most people don't care, right? So we reserve like a half, either left gallery, right gallery, the last row, if anyone's going to be observing here in the courtroom during the voir dire process, so that we're very clear that they're distinct from the jury. We don't put them in the front row because we don't wanna have an issue of somebody saying, guess what, they're overlooking their shoulder and they can see them writing notes or whatever. Put them in the last row, then there's no one behind them, right? Then nobody has to worry that they're close to somebody's council tables.
yeah, what we did, Your Honor, we had our clients coming in and out during the process. Not everyone can be here every day, so I would suggest that we do leave some space for party representatives to be here.
Okay. Okay, counsel for real water, your thoughts, go ahead.
Yeah, we would agree with Mr. Parker. For our side, we would have approximately 7 to 8 people when we factor in if observers were coming from carriers to watch.
I'm only talking voir dire process, right? Because we'll have a lot more seats during
Yeah,
trial.
so for voir dire, we would have 6 people.
Okay. PGT, Terrell Herbst.
We would probably have 2 at the most, Your Honor.
Okay. Do you all want them on both sides, left gallery and right gallery, or can we reserve just either a left gallery or the right? Normally, we reserve the very last row, right gallery, just to let you know, okay? It's kind of the observer row. The reason why we do that is, well, most people find it the easiest. The only time we do the left side gallery is we've had one person say at one time that since those last couple seats in that far right corner, it's kind of hard to see around the marshal, that they prefer us to seat their observers on that side, but since
That makes sense.
normally observers are sometimes more likely on one side, on the defense side than the plaintiff side, they don't necessarily always want to sit on the plaintiff side. We prefer not to reserve the whole back row unless you really need it, because it takes away from your prospective jurors. What do y'all want?
So, Your Honor, I prefer, and I hated that you just said what you said at the end of that, but I prefer to split them up, actually, one side or the other. But one thing that we did in the last trial is we had our clients, when they did show up, we had them sitting on this side of the wall here, because there's
Yeah, on
only
your side,
3 or
you
4.
like where Mr. Godfrey is?
Yes, but they would be, to his right, perhaps. The only problem with that I can notice is sometimes the people in the
This-
gallery may not be able to see over them. They may be able to, like you said,
Okay.
hear them. But the reason why I think splitting them up is important is because from time to time we'll have a conversation with them, and it'll be difficult if we have the defendants mixed in with them. And I would say the same is true for the defendants having a conversation with their representatives.
I was kind of making a distinction between observers and clients, okay? Clients, usually people working to their own table scenario, okay? What we don't do is we do not put clients any further than where Mr. Godfrey or Mr. Pepperman is. And the reason why we don't do that is you're just
Absolutely.
too close to, you know what I mean, to the jury.
Agreed.
So, if you, and that's one of the reasons, just to let you know, remember I mentioned we walk the jurors coming into the box, yes, I'm using my hands, we walk them down the hallway and come in underneath the big TV and come in that way, because we are fully appreciative that sometimes you need an extra chair in that middle way, right?
Yes.
For purposes of clients, sometimes people, it's hard to get up and come out, and sometimes people want to go in and out, and they want, kind of leave that as their extra chair, which is fine, but, so basically you all want me to reserve that whole last row for people. I will not mix potential jurors in with clients or observers. It just, do you need a sec?
I think that makes sense, Sean.
Did you need a sec, if you need to take a break, let's put it.
I just swallowed them.
Anyways, okay, then you've lost the last row, then we'll do the last row, okay? And then your clients, do you have enough space for where your clients and your counsels are gonna be?
Yes, Your Honor, Joel did for a while, we have enough space over here with 2 chairs, that's all we would anticipate for voir dire.
Okay. And ETT?
The same, Your Honor, I would, Valerie Rojas for chair boards, I think we could fit the 2 here.
Okay, so you need 5 in the back row, and do you need 5 up here? I'm just gonna ask my marshal to
Yes.
do a chair seating. Councils, you need,
Your Honor, we have 5 plaintiffs. Will we need them every day? I doubt it. So I would suggest if they're not gonna put anyone in the back, we reserve a few chairs in the back here and separate ours.
and just
But
to
not
be
for
clear-
observers. We don't have any observers coming, Your Honor.
Okay, just to be clear, I'm not requiring clients to sit in the back row.
Got it.
Clients have a right to sit up with their counsel if they choose to do so. I'm just trying to find a space management way to address this. Observers are different, and I appreciate that carriers might fall in kind of a interesting aspect, which is why I'm asking what you all want, okay? That's why I'm trying to go for seats. So
We're good, Your Honor. Mr. Godfrey intends to sit here.
he cannot sit behind the bar. He cannot sit in where the jurors are.
So
Yes.
then Mark probably will not be able to
Unless he's
sit
in the
there.
last row. If he's in the last row, he can sit in the last row. He cannot sit.
After what here, Your Honor?
Oh, after voir dire, that's fine.
All right, so then that'll be fine. We could probably put 4 or 5 people here next to Mr. Godfrey. We should be fine.
Okay, we can put Miss Brody where you need to. She's got ingress and egress. Okay. Okay, yeah. That's what I said. If you have extra people, they're going to be last rows. Can't take up first rows. Okay. So we'll do the math count to get those people in. Now, generally for voir dire, the way this, I know different departments are different, we have some trials in this department, is we usually do not do a strike day by day. Usually it's after everyone has exhausted their questions, then we give you a sheet and you pick out. Laura, do you see a sheet?
I looked.
Steve's, on the marshals, do you see over there? Was there a sheet?
What are you looking for?
My 12 juror sheet. Staff, do you have a copy of it? 12 juror sheet? This is a 10-1. Okay, good 12.
He doesn't turn you over there, that's all I saw.
Okay, well, if you hand me a couple of these, I can show them.
Okay.
You have some of these?
Yeah, these are all.
Oh. Okay, well, I'll show you by example. And Marcia, can you just show us the place, then we can show it to defense counsel. This is a 20, this isn't a 24, okay? We add extra boxes. It's just how we set the jurors in, okay? And then we're gonna pass it around because
Yeah.
we're looking for our 24.
Yeah, he only has 20, so he doesn't have any there.
Okay, can you give one to ET&T and one to plaintiff's counsel?
Thank you.
Plaintiff's counsel's over the next, other side of the table, please. Mr. Kemp is going to come down. Okay. That's a 20, a 24 is gonna be similar, okay? So, the way we generally do it, subject to what parties want, is, yeah. So, the 10's different than the 12, okay? All right, so we normally would fit 4 in front, and you do 2 sets of 10 in the back. We do 3 sets of 8. Do you all want 3 sets of 8?
That's fine, Your Honor. The way it's set up right now, you have 17 in the box and 7 outside.
Right, which is
It's
fine.
close enough.
You like that, 17 in the box and 7 outside? Really?
It doesn't really matter, Your Honor, as long as we have enough that we could do, at the end of the day, preempts and you have 12 left, that's all that matters.
Okay, sometimes people have a specific preference. Do you care?
We do.
You're fine as is?
That's fine, Your Honor.
Okay, so then we'll leave it here. You got 24. So that chart is gonna be changed, obviously, to do a 24. The only reason why I'm really showing you the charts, what we usually end up doing is, after plaintiffs has finished their voir dire questions, then we would address any challenges at that juncture, right, for cause. We don't do it midway through. It's not like you'd ask all the exhaustive questions of potential juror number one and then say whether it's passed or caught. You know, we let you do the whole panel. It's just quicker, easier, you get a more flushed opportunity to see everyone's responses. And then when plaintiff finishes, either plaintiff passes for cause or plaintiff, says, may we approach, right? Or somebody says, may we approach. Now, I'm going to address their approaching in a second, but let me walk through it, and then it would be, based on you all's order, then it would be Real Water, would be asked their questions, and then ET&T. So this raises a couple of different things. First off, bench conferences are not part of the official record. You're hearing me say that in all caps. So, do you all want peremptory challenges to be done at bench, or do you want me to excuse the jurors and you? So once plaintiff has completed all their voir dire questionings, in a standard way, what would happen is plaintiff would either say, may we approach, or we pass for cause, right? If you say, may we approach, the appropriate counsel come forward. I hear if there's any cause challenges. I hear if there's anybody telling me that they want to rehabilitate or whatever they wish to say. To the extent that the court can make a ruling, right, then there at bench I would make a ruling, and to the extent that things get deferred until after people have an opportunity to ask their questions, they may get deferred, and then those challenges would be first once we get to the defense's questions. Sometimes people don't wish it to be at bench. They wish then to excuse the jury for a break and then address all those peremptory challenges outside the presence of the jury. Some people like the quicker version at bench, some people don't. This court does not have a preference. Let me know what the parties want.
Judge, can we go back to the all caps comment again? Are you indicating that the sidebars aren't being transcribed?
That is correct. That's why I said in all caps. Yes.
Okay.
No sidebar. That's why I remind parties multiple times pre-trial. So if you're coming to bench, realize it's not a recording. So if you want something on the record as part of the transcribed recording of this trial, you need to say when you come to bench, Your Honor, we'd like to excuse the jury and we'd like to discuss this at council table, okay?
Okay, thank you, Your Honor.
Or words to that effect, so that you make it part of the official record. It's really just way too challenging because with the white noise going on, the various voices, depending on people it gets so jumbled, there's really not any clarity there, that the easier way to say it is to leave it to the counsel. You're sophisticated enough to say, look, we want this outside the presence of the jury, then you have a chance, right, to articulate what you wish to articulate, and not have to worry about jumbled and people saying that the transcription really clear, not clear, it makes for a clear record for parties, okay? So, but please do not ask me once I start ruling, or after you've given your argument, oh, now we changed our minds and we want it at council table. You gotta tell me when you first come forward, because once I start ruling, that's a ruling, right? So, okay, that's the thing that the court asks, so that way we're just nice and clear on the record. Mr. Parker, I think you're about to have a question. Go ahead, please.
Your Honor, is your ruling on the official record, or is your ruling kept at the bench as well?
Generally, if it's something similar, like peremptory challenge, right? Okay, somebody raised an issue. I mean, they have a cause challenge, so-and-so, whatever, they're biased. The other person wants to be heard. If that's all done at bench, then that is not part of the official record, okay?
So,
If you request that you wish those to be done outside the presence, then we can easily do that, outside the presence on the official record. The challenge that happens is if the court says something at bench and then you ask to repeat it, sometimes people say it's not exactly word for word. I try my darndest, but you can appreciate, might have an in there or something that I may not have said at bench, okay? So we try and keep it clean one way or the other.
so for example, Your Honor, during voir dire, I ask a question, I decide based upon the response that we want to challenge the cause. We complete using your approach, we complete our questions. I come up with a list of 7 or 8 veneermen that I believe should be released for cause.
Okay?
That discussion would happen at the bench, I'm assuming,
You have two choices.
unless I ask for it to be
Okay.
done outside the presence.
Right. usually include the court, you'd say is, Your Honor, may we approach? And you say, what's your approach? Your Honor, we would prefer to do this, have the jury excused, we wish to do this at council table, so it's part of the official record. Do you have to say all those extra words? No. As soon as you say, we'd like to do this at council table, or, on the record, then fine. But if you start giving the list and saying you want to start raising your positions, then this court views it that you want it discussed at bench, because in fairness, you've already started with part of your argument, so why would you get 2 bites of an apple, right?
No
Usually
worries,
that somebody else objects to it, so,
So then, let's play this out.
sure,
We opt for the sidebar.
okay?
The court decides that you're letting 3 of the 4 out, and the 4th one you're keeping in.
Okay,
So we go, the real water would start next, and real water would have the opportunity to question one of the ones you kept in.
mhm,
So the ruling, I guess, would be self-evident in the transcript, because that person is still there and being able to be questioned by real water. But your decision for that, your underlying reason for that decision would still not be a part of the official record, correct? That's how I'm
under
taking.
your scenario, yes. So what would happen is, let's take a hypothetical. Say you
Yes.
raised a challenge as to jurors 1, 2, and 4, okay? You come to bench, you say, I remember, the court does it in the order that you raise the challenge. So if you do 1, 2, 4, I go 1, 2, 4. If you do 4, 2, 1, I do 4, 2, 1. If you do 2, 4, 1, I do 2, 4, 1.
Sure.
And as you know, that matters because of your alternate issue, which we're gonna get to in a second. Okay, so what made my life easy for this example? 1, 2, 4, right? So 1, 2, 4. Counsel for real water and terrible Herbst stipulate to 1. 1 is gone, so once we finish the other ones, and say you didn't request to be at council table. So once we're done, the court's gonna thank and excuse 1, okay? 2, you seek to excuse, doesn't really matter, terrible or real water, it doesn't matter if it's both or one of them, says no, okay? So I would hear the argument at bench if you're requesting bench, okay? And then we make a ruling. Say the court says, well, 2's made this statement, such bias, whether I cite case law or I just say, see case law, usually you all believe the standard brief, right? That has the jury objections, maybe I might not get that standard bench brief, but usually one side gives it to me, okay? So, 2, I say no, 2's gonna be excused. 4, there's a question on, right? Court can't make a ruling. So then what would happen is, once you all walked away from bench, the court would say, the court thanks and excused juror number 1, the court thanks and excused juror number 2, because that's the order you've done it, and then,
Juror number 4.
well, I wouldn't say anything about juror number 4, because 4 I'm deferring on.
Right.
Okay, so then what would happen is Madam Clerk would then go the next 2 in order, and make it the very beginning, right? So the next 2 in order would be number 25 and number 26. Number 25 would go to seat 1, number 26 would go to seat 2. Plaintiff would then have an opportunity only to inquire on jurors who now, the new 1 and 2, which were seats 25 and 26, but now we're 1 and 2, right? You've completed those. Make my life easy on this example. Now you passed for cause, now I'm passed for cause subject to prior rulings of the court, right? Okay, so you reserved your 4, but you've now passed. Goes to real water. Real water does all their questioning, okay? Real water, now this is where I'm gonna have to ask whether real water wants to wait until after ETT or real water wants to come back to bench to raise its own, because we have to get into the, are your interests aligned on your peremptory challenge issue, right? Not for cause challenge, but okay. And sometimes the parties wanna wait for defendants, to have multiple defendants ask questions, sometimes they wanna do it defendant by defendant. I'm gonna get there in a second, but for this purposes, under this hypothetical, real water wants to come to bench. Real water comes to bench. Real water, in my example, has raised the issue on number 4. So first I would deal with plaintiff's challenge on number 4, and then real water also has a challenge to number 9, okay? So I would rule first on 4, and then go to 9. 9, now, it's a little bit different, and once again, this is where it's gonna play out a little bit differently, is if real water wants to wait till after ETT, right? Because I may still have to defer my 4, because if both real water and ET raise an issue, right, and then I have to defer till both of them, which is why Oftentimes, if there's only two defense counsel, they wanna wait until after they've both exhausted questions, but that's not a requirement, that's just okay. But in this example, they didn't. So if Terribles had not objected to 4, I'd rule on 4, and then I'd go to number 9. If Terribles had also ruled on 4, then I might say, look, I've got to do this, I still need to defer because Terribles also had objected, okay? Or wanted a chance to rehabilitate, okay, in this regard. 9, I'd rule on. Say I replace 9, because you all stipulate or over somebody's objection really doesn't matter. Then what happens, and this is where it gets a little bit more challenging, and I need some guidance on how you all want to do it, is some people want to just finish off so that defendant Real Water would only question number 9, and then it would move to Terribles, and they'd be able to question the whole panel. And then it'd go back to plaintiff to question 9 and any new people that come up from Terribles. Other people want it to go back to plaintiff first, just on 9, then Real Water, and then Terribles would have the whole panel. Once again, this court's flexible with any of those. What works for you all, and maybe you all had the way you liked it in your last trial that you want to do it, okay? I need to hear from you for some input there. But to answer your direct question, I think I've answered your direct question on what the court would say on the record. I wouldn't be giving my analysis, look, that person blurted out blank, they have shown such a bias under the applicable case law that, look, they said there's no way that it can be rehabilitated because case law says, what you say certain things you can't, right? Okay, so why don't I hear what you all would like to do and see if that is doable, because the court's not wedded to this, so.
So, Your Honor, there's a couple of questions that you raised based upon that process. Number one, the ability for either side or all three parties' counsel to traverse the veneer person after they've questioned someone who's already been sought to be challenged. So, and under your scenario, Real Water objected to my cause challenge on number 4. Real Water.
Only Real Water?
Only Real Water. It really doesn't matter, but in your scenario, we use Real Water. So Real Water is going to have a chance to talk to and question veneer person number 4, because you've allowed 4 to stay on at this point. You
Correct.
got rid of 1.
They have the
got
whole
rid of
panel,
2.
they have the whole.
They got the whole
panel
panel in addition to 4 is a part of the whole
Right.
panel. Now, because Real Water gets a chance to question number 4, Real Water may bring up something that is new in terms of Real 4's experience, history, potential bias.
You still would have a chance to
I
challenge.
would still, bingo.
Yes.
So that's number 1. So plaintiff's counsel would have an opportunity to traverse that witness based upon the new discussion.
Each party has an opportunity to raise a challenge to somebody after they, that's already out there, yes.
So the reason being, Your Honor, you call it to rehabilitate. When you consider the case law, the reason why we have such, I would say in this state, good voir dire Supreme Court decisions is because most of those discussions took place on the record. And so my question to you was, you're giving us the opportunity to make that record if we ask to do it outside the presence. So you've cured the
I get
real
the
issue.
choice. Some people like the quick idea of being addressed at bench and get it done and taken care of. Other people want it all on the record. The court doesn't have a preference.
Okay, that's fine. The easy ones, Your Honor, ones that don't pass the case law we have in our state on cause challenges, those are ones that can be handled at the bench summarily, I agree. The ones where I suspect there's a question regarding outward bias, when Real Water objects, then those are all likely will be handled outside the presence. What we've tried to do, and I think that we were effective the last time, is by doing it somewhat differently. You don't give the panel insight on how to get off the jury. And that's something that we've always been concerned about, because there's a lot of motivated people trying to get off the jury. So you don't want to do it so it makes it easy for them to figure out, okay, if I answer this way, I can secure my freedom, so to speak.
Which is one of the reasons why this court does not do person by person while we're in the middle of doing the voir dire questioning, because that usually boom, if you do someone midway through, they're like, ooh, I haven't took this way, I'm gonna
Exactly.
do it, boom, that's the reason why the court waits till someone is fully completed before cause. It's one of the many reasons why the court waits. Go ahead, please.
And so given that the court's giving us the ability to do it either way, in by sidebar or outside the presence, I think we can work with that.
But I need to know before the trial starts which way you all want it, right?
That, I'm fine with that, Your Honor. I've
Go ahead, please.
done enough trials in a lot of different ways, and I'm fine with that.
Okay, so what's your proposal, what you want or you thought was effective? I mean, you know, Sanders and some of the case law makes it pretty clear, we just try and make sure that we're compliant with the case law.
I think the quicker way, Your Honor, I agree with what you're saying in terms of doing outside the presence or doing it at the end, but I think at the breaks, that's worked best. Because you take a break in the morning, you take a break in the afternoon, you have a break at lunch, we can give them to you then, and it's quicker because you're bringing in new people faster as opposed to making people sit through me questioning 24 people up front. So at the breaks, to me, works the best.
The challenge with what you're saying, and like I said, if you all agree with it, if I got unanimity on a particular way, I'm gonna be okay with it, okay? One of the challenges with what you're saying is, say we take our morning break. Say you've only had the opportunity to ask 5 to 7 questions, doesn't really matter, okay? Of the 20 questions you're gonna ask, in my ideal world. Yeah, right, okay. Yeah, well, okay. I get to create my
There you go, you brought a little, comedic.
I got my own hypotheticals, right?
Yeah,
I
that's
create
great.
my own scenarios, my own hypotheticals. Okay, so your 5 to 7 questions of your 20 the questions you're planning on asking the jurors. If I addressed cause challenges then, and did this in one trial, is there were so many requests of look, that counsel has not finished the questioning, we don't have the totality of what that witness's answers would be. Particularly, there's certain types of questions that get asked, right, which have lots of follow-ups, right? That there may be books about, that may involve certain species of animals, and other things, right, that come up a lot. And so when I get those, we haven't even heard plaintiff finish and exhaust, and we really think that those may, from the totality, right, and if you're looking at an isolated question, that's the problem with doing it at a break midway through one side's questioning, is the number of issues that come up from the other parties that say, well, you haven't even heard the totality of their questions in addition to our questions, and then can be problematic. Now, if you've gotten through 18 of your 20 questions by the break, there may be a difference in it, you know what I mean?
Yeah, I would suggest, Your Honor, that the break process works better because you don't have potentially veneerman number 1 waiting for me to get to veneerman number 24. That person is gone, a new person is put in that space, and we get a lot more done quicker, and we get people shuttled in and shuttled out.
So are you saying you ask juror number 1 your hypothetical 20 questions, and then you decide whether you're going to want to do a cause challenge on that juror, and then you wait to the break and maybe you've gotten through 5 jurors on your 20 questions, in my example?
If my approach, and Mr. Joul's had the pleasure or displeasure of living through it, is I ask questions of the group, and then I come to each veneer person individually. The group questions sometimes result in a person giving a very candid, they're going out within seconds of that remark. We had a person who said right up front, as soon as the answer came out, I think every attorney, the judge, the clerk, everybody said, okay, that person's gone. There's no need to make that person sit there for the next 2 hours. And that person had a potential of tainting the entire process. We probably could have thrown out everybody else if we let that person stay there.
Okay.
So I've learned in 30 years of trying cases that if there's someone I know that's going to get out, and typically if the other attorneys have read the case law in this area, they know who's going out when they hear a response like that. And there's no need to keep them there.
Let me get a I usually would say unless the person's being so obstreperous, we need to address it at that juncture. Yes, we have some people who will express their viewpoints no matter what and say that they're going to get off the panel, and that can be disruptive. Let me hear from everybody else on their thoughts, and then let's then circle back which way you all want to do it. So, Mr.
I don't know if I can just.
Yeah, whoever,
I mean,
it's fine. Like I said, they have multiple writers,
right,
of course.
Mr. Parker pretty much summed up exactly my viewpoints on this from my experience on trials in other states. It's really nice on breaks to be able to, first of all, confirm maybe we have a stipulation, and we take it to the court and say, all parties feel this person's a cause challenge, and we would put it to the court that way. But also, there occasionally are individuals that are so clearly a cause that it's almost unfair to like leave the person sitting there for the rest of the day when everybody's like knows that person's done, or that person standing up and spouting some manifesto or something that might potentially taint the rest of the jury panel. I mean, I think
Okay.
it
So
would be easy enough just
walk me through what you're suggesting. I just want to see, like I said, if you all are on the same page,
Yeah.
just tell me what that page is, and as long, what the court does not find productive is, well, first off, on your general questions, only to the box. Your questions are only to the
Absolutely.
people in the box. We do not do, other than hardship, right, and qualifications,
Right.
that gets your left and right gallery, it's only to the box, because otherwise you're gonna have person number 56, whatever, spouting off a whole bunch of things, and that person may not even get near a box, and it just takes too much time. But, other than that issue, propose what you're suggesting, and, like I said, well, first off, don't you all agree that you don't want your gallery people answering questions? I mean,
I
does it-
certainly agree with that.
do you agree with that, Councilor Hutchinson?
Yes, absolutely.
Councilor Plaintiff?
I do it either way, Your Honor. I'll do it if the court prefers. I ask the gallery questions typically if I believe that we can get some people out for their time. I'll give you an
Yeah.
example, Your Honor. This makes perfect sense in my opinion. There may be people here who can't hear very well, can't understand the English language very well.
But
who
you already have
have-
juror questionnaires that
Your Honor,
parse those.
I've had jury questionnaires in a lot of cases, and you still get Mr. Odou. I think every attorney in this room who's tried more than one case can tell you. They'll go through a jury questionnaire, and they will still come here and ultimately tell you, I'm understanding 1 word out of 10.
Oh, no,
because
we get
my-
that all the time, they usually
And so
stop.
I'll ask a few general questions, because some judges actually do those general questions in terms of qualifications, time.
Circle back,
Okay.
because remember I gave you, remember the court gave you the court standard 11 questions, gave them to you the other week? Do you want the court to ask that or some subset? Because that's gonna answer part of your question. One of the reasons, I may have mentioned this, if not I'll mention it now, is one of the reasons why we do those general questions. I know I went through the fact about it oftentimes makes the jurors feel more comfortable by reading a couple questions or some generalized background questions before they have to answer someone face to face.
Sure.
Attorneys like it, jurors like it, because you get to see. The second reason is if somebody's gonna start to being obstreperous, answering some background questions, they start with a manifesto, to use your words, Mr. Love, okay? They're gonna start it right then and there, oftentimes. They're not gonna wait till some questions, and if they don't wanna be here, they make it clear at the very beginning. And one of the third reasons is it addresses the language issue.
Good.
Is if someone can't read some very simple, basic questions, it gives you all an indication that there may be a language barrier without embarrassing the person. Is because if they start to read it and they can't really read it, oftentimes I just take it up and read the question to them, okay? After I give them a couple of chances to do it, okay, and let them go to the next question. So it doesn't embarrass them, but it gives you a clear indication if there is an English language issue. Yes, because we get those all the time. Sometimes people do it when we start with the hardship, they go to the language barrier issue. For the disability aspect, we cannot knock people out of the box. Ladies and gentlemen of our community are more than welcome to participate in a jury if they have any disability. It's only if they choose that they feel that their disability precludes their service, then they can assert that if they wish to do so. But we are more than glad to accommodate any disability, and everyone has a right to serve on juries in accordance with, very broad rules that we have with regards to people who can sit on juries. So that's part of the court's standard questions, is to address some of those issues, which is why we don't have counsel start going to the gallery, because you'll usually find somebody who wants to say very long-winded answer, and they're usually in that last row, and it takes up a lot of time, whereas if you focus on the box and you tell people in the gallery to please pay attention to the answers of those given in the box, so that when they have their turn to come into the box, they get the opportunity to come into the box, then they already have some of the information from the background, and then that way it expedites things. So the gallery.
I can confine my questions to the box, Joanna, that's not a problem.
Okay.
But I think at least me and Real Waters Council at this point, you haven't asked
I'm getting to them
ETT's council on the
next.
same page.
Okay. Counsel for ETT, Terrell Herbst.
Yeah, Your Honor, typically I do it by bench, so, but I understand if we need to take a break, I have no objection to that.
Okay. So here's what I'm hearing from you all. What I'm hearing from you all is that you would like this court to ask you when we take a morning break to have the jurors go out for a little bit longer and have you come back earlier to see if you wish to address any challenges at that juncture by agreement of the parties. If the parties do not agree, if anybody requests this court wait until the conclusion of whoever the counsel is that is questioning, then I will do that. But if you're all in agreement that I can address some of the challenges at that time, I will do so at the break. Would that meet everybody's needs?
It would, Your Honor. Thank you so much on behalf of the board.
Pardon?
Yeah, that's fine with real water, yeah.
Counsel for UT&T, does that meet you as well?
Yes, Your Honor,
Okay.
thank you.
Because that way you all really have a chance to see if it's an issue that you want to do, okay? And then we can address it in that regard. FYI, you may need to remind me, because that's a little different than what we normally do, okay? So just say, Your Honor, is this one of these breaks we can give the jury just a little bit longer or something? Thank you, give me a clue. But guess what, you might want to have you all come back in, okay? And we can address those, that's going to be fine. And once again, if somebody's so obstreperous right in the middle of it, oftentimes I'll just say, counsel, can you would like to approach for a brief moment? Or one of the counsel just says, Your Honor, can we approach for a brief moment, okay? That's it. We even had people water break. And different things happen that, we take care of them immediately. We don't make them wait to breaks. We get them taken care of, okay? Or prevent emergencies. Okay, so that takes care of 12 jurors, 4 of them will be alternates. Do you want the alternates seated in the last 4 seats, or do you want them interspersed between the jurors that we go back for deliberation?
Last 4 seats, Your Honor.
Counsel for Real Water?
Yeah, no objection to that.
That's fine, Your Honor.
Okay, so last 4 seats. Now here's the other question. I've had one counsel, normally seat number 1, as you can see on that little chart, like I said, is 20, not 24, but it shows you normally seat number 1 is that far back corner. Okay, which means your seat number 24 is right up front. That's the way we generally do it. We have at least one occasion I can think of where counsel thought it would be different to basically go in reverse, so that seat number 1 was there, and we did it backwards, because they wanted the jurors that were actually going back to deliberation right clear in front of them versus being in the 3rd row. Is that a request here, or can we
No, I
start
like it
number
the
1
way
in
you
the
have
far?
it, John. I like it the way you have it. One top left, number 9, right below it, and then
24
number
seat.
7, 18 through 24 in the front. 24 being the closest to Mr. Pepperman.
Okay, Councilman Water, does that meet your needs for the order?
Yeah, I mean, that's fine.
Okay, Councilor ET&T?
Yes, that's fine.
ET&T/Chair Lawrence. Okay, so we got, anybody have any other juror seating questions?
Your Honor, just one. Given the ongoing change to the new system,
Ongoing change to what new system? Just which way?
in the jury services, in terms of the new program or software that they're using, they indicated that that might result in a change in the order of how jurors are called in terms of badge number, ID number, or panel number. Do we know which number is going to be used for purposes of calling the jurors in
I don't.
sequentially?
I
Okay.
don't, is the answer. Whether you know, because sometimes you all find out ways that things I don't know, but I think let me ask Mariah, okay? So let me send her an email. Because what is I will ask her the open-ended way is, right now they have a juror number and they have a badge number, but remember, because of the way this was done, it was in batches, it did morph a little bit.
That's correct, Your Honor. They have a panel number as well. and they're all in different sequences. So we don't know if juror number one is badge number 1, juror ID lowest sequence number, or panel member number 1.
So what you wanna know is if 1, 2, 3 on your listing is really 1, 2, 3, and they're coming up, or whether they may be 156, so they may not, or they are.
Or which number is the lowest juror for, will be juror number 1, and so on.
You need some kind of cross-reference. If there is going to be a distinction in the numbers, let me find out the answer to that.
Thank you, Ron.
Any other questions that you all need answers to? Anything that? Everyone understood what that question was, right? Okay. And you were down to, we were at over 1,000 had come in. So you all have a couple hundred, where are you number-wise on how many people are left or potentially coming in? Do you have a ballpark?
I believe we have 1,000, a little more than 1,000 jury questionnaires filled out, and then,
Right, you had over, 1,009 at one point, but then you had some stragglers.
and I don't have the numbers on the numbers of agreed upon excusals, but I
The short
think we're
answer
more
is
than
you're
enough.
fine, you got more than enough, right?
We're more
You're
than-
taken
we have
care
more
of-
than enough.
Everyone's taken care of with your, okay, okay. Because normally what jury services, and you probably did this last time, is they're only gonna call in like the first 50, 60 for your first day or two, okay? I really don't see with the small number of parties. Okay, let's get to the hours question. I do it in hours. How many hours does plaintiff's counsel think that they're gonna need for voir dire questioning? And the reason why you can appreciate I do hours because everybody's days are different. Sometimes people tell me when they say a day, they really mean 24 hours, some people mean 8 hours, some people mean 6 hours. So I do it in hours. How many hours does counsel for plaintiffs think we need for voir dire?
Your Honor, I think I took 15 hours the last time,
Counsel for real water.
virtually a day and a half, 2 days and a half.
I thought you said 18 before, but
Hey,
who's counting?
I'm trying to get down a little. You're welcome.
right, but here, it's, I mean, the court's not taking any legal position, but don't you have a little bit of uniqueness on the actual claim that's left and what's left for the parties so that you don't have as distinct as you've got some nuances that are different than Gallagher. Counsel for real water, go ahead, please.
Your Honor, probably 2 to 3 hours, I think.
ETT, Terrible Herbst?
I would estimate about 3 hours.
Okay, 6:15, 21, okay. We had ballparked it for the 3 days. 3 days is really closer to around 18 to 19 hours, right, to get people in with breaks and stuff. Counsel for plaintiff, I might be chopping off a couple of your hours, okay? Because, do you really want your potential jurors here more than 3 days?
No,
for
Your Honor.
jury selection? Don't you want to get started on trial testimony by Thursday?
Well, the way we were looking at this schedule, Your Honor, my belief is we should be hopefully done with openings on Friday, the 19th, and start our case in chief on the 22nd of January. That's how I was looking based on my schedule.
Okay.
But I typically don't leave much left for questioning, so.
But they have a right.
And
Counsel.
listen, I want them to
He's
do
helpful.
whatever they do. I find myself helpful. I do a lot of defense work, Your Honor, so I think the questions I ask
Okay,
go both ways.
right, but you understand, with 21 hours, that doesn't get you where you're going. That's why I said closer to 18 hours, right? I meant to say Friday, not Thursday, because remember, it's a shortened week. So if you're ballparking still, trying to do openings
On Friday.
Friday morning, because you usually, if you bring jurors in to finish out voir dires only for like an hour or two in the morning, you know what that, well,
Again, Your Honor, we're predicting that we should be done with voir dire by close of business on Thursday and be prepared to do opening on Friday.
everybody's voir dire, not just yours.
That's the plan.
Okay, which means you may need to trim yours a little bit, because do the math. 21
I-
hours does not get you, with where the days are. And remember, I do have other motion counts we have moved. Where are we? Ooh.
I think that Mr. Odou can attest to how much is left for voir dire after I get finished. Your Honor.
Got a whole bunch of status checks, okay. Because remember, we're not,
And I suspect that Ms. Rojas' team has reviewed the transcript, so I venture to say that there won't be much left for them.
By the way, oh, you know, I haven't refreshed a couple of those things in this case. Pardon? Yeah, no, I'm just saying, I was looking to see, because remember I do have numerous other matters on the calendar, so I'm just trying to get those taken care of as well, because I'll have a better idea next week on starting times. Our hope on the 16th, since we're now not doing your motions, I'm trying to quickly look at some of where we're at. Status checks. Probably 9:30 start, this is ballpark, okay? Subject to, you know, sometimes attorneys like to talk more than I anticipate. Probably 9:30 on the 16th.
Sounds good, John.
17th, 9:30-ish. Got a special setting at 8:30, but it's still certain. The 18th is a little bit of a challenge. 10 or 10:30 on the 18th. Then we have civil motion. Yeah, I got a whole bunch of status checks, okay. And that's assuming that,
And what do you have on the 19th, John?
19th should be 9 o'clock,
9 o'clock. Thank you.
ballpark, and, yeah. 19th isn't the issue. 18th is, the 18th is my challenge. Okay, well, that's my best estimate as of right now. Subject to including some of your firms have some things that you've asked me to move around, so be careful when you're asking me to take up time for one case when you have this case. But that's where I have right now. Okay, exhibits. Did I give enough time? Did people pass their exhibits?
Your Honor, Joul did for Rural Water, we have not received any communication from
Okay.
the.
Your Honor, I heard from my office the defendant's exhibit is passed, so we're good on it.
Thank you, sir.
Okay then. Okay, so both defendants are all passed. Okay, so we don't have any exhibit issues. Okay. Depots, thank you for the boxes of depots. Thank you for the sheets outside the depots. I was going to, I have two ways of doing this. There were 10 boxes of depots. Normally, we would read through what depots have been provided for purposes of this case. Realistically, I was going to do your sheets with your 10 boxes. Can I make it just a Court's Exhibit 1, which are the depots that are lodged for purposes of this trial? Or do you want me to read them all out? First off, are those 10 boxes everybody's depots? Do people know what I'm talking about, the 10 boxes?
Your Honor, Joul did for Rural Water, we'll get with plaintiffs, we haven't seen that. We
Okay.
obviously want to make sure that all of the positions have been logged.
Let me read them off then. Let's just make sure, okay? Because all depots were due out of before the calendar call, so if somebody thinks, did anyone else provide the court depots other than the 10 boxes from Kemp Jones?
No, we had no original depots, Your Honor.
Councilor Real Waters, you?
I don't believe we had any original depositions, but we
Okay.
wanted to make sure the parties who have settled depositions, if there were any, did get submitted to the court.
Okay, so let me tell you here, box 1, I'm just saying what the boxes said, okay? We have not independently verified these, this is just what the box sheets say. Box sheet said, John Marlowe, deposition date May 10, 2021, December 16, 2022, and Raymond Ray White, February 16, 2023. Box 2, Blaine Jones is PMK for Real Water, confidential, January 12, 2023. Blaine Jones is PMK for Real Water, redacted, January 12, 2023. Blaine Jones individually, Feb 23, 2023. Lois, and I'm not saying that these are admitted, I'm just saying what's been presented, okay? Lois Kessler, March 20, 2023. Thang Tom Pham, March 21, 2023. Those were box 2. Box 3, Robert Trey Fisher, April 6, 2023. Diego Mendagana, April 14, 2023. David Goldsmith, MS, PhD, May 18, 2023. Rima Capedia, May 30th, 2023. Charles Nesland, Eurofins 30B6, May 31, 2023. Box 4. Susan Richardson, May 31, 2023. Annette Santamaria, PhD, June 7, 2023. Carly Kinslow, PhD, June 9th, 2023. Eric Benolkin, September 8, 2023. Michael Marsh, September 27, 2023. Kenneth Rathall, September 27, 2023. Robert Gallegos, Nevada Beverage 30B6, September 29, 2023. Christopher Jody Kemp for ETT 1, 30B6, October 3, 2023. Box 5, Samuel Stelfog, if I'm mispronouncing names, I'm doing my best. October 24th, 2023. Yuna Gong, MD, oh sorry, the first one was a Samuel Stelfog, who is also an MD. Yuna Gong, MD, October 26, 2023. Alex Revchuk, DNV PEBCES, May 16, 2023. Now it's unclear because now there's a blank line that then says October 30, 2023. Was there 2 volumes of that deposition?
He was deposed a second time, yes.
No worries. Okay, thank you. Box 6, Dennis Postenbach, PhD, June 2nd, 2023, and a second one, October 30, 2023. Arik Cohn, October 31st, 2023. Gordon Hayburn, October 31st, 2023. Scott Tenner, MD, PhD, JD, May 25th, 2023, and November 1, 2023. Brian Breeden, November 3, 2023. Box 7, Matthew Sims, MCMS, November 3, 2023. Melissa Keddington, RN, November 6, 2023. Angel Alcina, November 14, 2023. Anthony Randolph, December 11, 2023. Patricia Converse, December 12, 2022. Jeffrey DeSoto, December 13, 2022. Box 8. Box 8, Mitchell DePrete, January 25th, 2023. Jason Brown, February 3, 2023. Robert Brown, February 8, 2023. Anthony Brown, March 7, 2023. Box 9, Mike Bush, March 15, 2023. Debbie Castillo, March 16, 2023. Susan Dorn, April 13, 2023. Casey Aiken, April 22nd, 2021. Box 10, David Ashenson, MD, June 5th, 2023, and October 26, 2023. And Tariq Amar, April 6, 2023. The court takes no position that these are admissible or anything like that. This is just, or whether or not those depos are actually in the boxes. We're just saying these were the sheets that were on those 10 boxes. There was 10 boxes and there was 10 sheets. So, counsel for plaintiff, is there any other depositions you wish to lodge for purposes of the calendar call and purposes of this trial?
Your Honor, there were 2 volumes of depositions for Chris Kemper that were in a prior case that were cited in the motion for summary judgment. I believe those have been ordered but not yet received.
Everything was due at the time that we're before the calendar call, so let me see if I have a waiver from other parties. Okay? Because
It's okay, Your Honor, we'll let that one go.
Yeah, we don't have an objection to that. I didn't hear any of the plaintiff depositions in what you read off.
well, you're right, because I know I didn't read Brody, and I know I didn't read Hunwardsen, but.
Or so Harsh
Yeah.
or Schaefer.
Okay, so let me step back and make sure. Okay, plaintiff, are those all the ones I'm asking you? Everybody, plaintiff, are all those ones you want to watch?
Yes, Your Honor.
Okay, counsel for Real Water, do you have any depositions to lodge?
Yes, Your Honor, the plaintiff depositions, none of those have been read off.
Okay, was there an agreement between the parties that plaintiff was supposed to provide the court said plaintiff's depositions? Because as you know, it's each party's individual obligation to provide any depositions they wish, EDCR 2.67 through 2.69.
Yes, Your Honor, I believe the depositions were taken by UNFW, a party who settled, and I believe we have received the transcripts and we can get them lodged.
Why did you not bring them at or before the time of the calendar call as required under the EDCR?
We miss it, Your Honor.
Find out if I got an objection, okay? As you know, they're required, and nobody really wants me to read 2.69 and what happens if you don't bring the things, right? Specifically says that the court's supposed to preclude them or take some other action. Is there any Is there an objection with regards to plaintiff's depositions not being brought or lodged for the court?
Yes, Your Honor, we would object to any depositions not being timely provided. I think it's,
Was there any stipulation or agreement between the parties that plaintiff would take the weathering oar and provide those depositions?
no, Your Honor, we don't even have the original. We didn't notice those depositions or schedule them or take them.
Okay, Terrible Herbst, your position.
Your Honor, we would need to track down the Hunwardsen deposition, that would be the only one, and I believe the original is with UNFI.
Okay, hold on a second, I'm circling back. There was a request from Real Water to untimely lodge depositions, right? Contrary to EDCR 2.69. I have an objection from plaintiff to said lodging. Does Terrible Herbst have an objection?
No
Or
objection, Your Honor.
No objection, okay. So, EDCR 2.69C, failure of trial counsel to attend the calendar call and/or failure to submit required materials shall, right, mandatory language, shall result in any of the following which are to be ordered within the discretion of the court. 1, dismissal of the action. 2, default judgment. 3, monetary sanctions. 4, vacation of the trial date. 5, any other appropriate remedy or sanction. Mandatory shall language the court must do, right? One of those within the 5. Since I have an objection, I don't have a stipulation of the parties which the court could have considered and then determine what to do. So, is there any good cause, Real Water, for purposes of not having any depositions when you all had your meet and confers and you knew today's calendar call and et cetera, et cetera?
We didn't talk about the lodging of depositions in the meet and confer. We
You're
missed
supposed to
it.
under EDCR 2.67, right? 2.67 specifically talks about you having to do so.
We spent all our time talking about the deposition designations.
Are those deposition designations for any of the depositions which were not lodged with the court today?
No.
Okay, is there any good cause for not lodging said depositions? Was there,
Yes, Your Honor, we believe we
what's your good cause?
unintentionally omitted them and they could be sent down to the court, probably not before close of business considering where our office is and the time of day, but they could be lodged, if not today, first thing tomorrow.
Okay, but counsel, you understand, I got mandatory language, so do you have any good cause? Was there computer issues, fire, health issues, misrepresentation? You understand all the different things which are good cause, not the, I'm hearing what you're saying it was inadvertent, but it's clearly in the EDCR, so I'm trying to have an understanding if there's any good cause for not doing it. That's why I was asking if there was any agreement with plaintiff's counsel, that they were taking the burden, right? And then they didn't do it. But that's not the case. I have an objection from them to lodging any of them, so I have to evaluate whether you have any good cause because, right? Obviously, the court's not gonna do dismissal of the action, that's too harsh. The court's not
Yes,
gonna
sir.
do
We believe-
default judgment, that's too harsh. But the court has to evaluate monetary sanctions, vacation of the trial date, or any other appropriate remedy or sanction. It doesn't give the court pretty much do nothing. I'm gonna have an objection.
Your Honor, we believe that there's no prejudice, good cause exists because it was an unintentional omission. The parties have been meeting and conferring in good faith extensively and have spent quite a bit of time over the holidays trying to get everything ready for this trial. This particular lodgement was missed because the depositions were taken by parties who have settled.
But they settled a long time ago. When did they settle?
Well, not that long ago, but yes, Your Honor, UNFW settled, what, a month ago?
Way before your 2.67, right?
Yes, Your Honor.
Well, I'm gonna have to evaluate the quick second. Counselor Plaintiff, if you wanna be heard, go ahead.
I just want to put on the record that the 4 of the plaintiffs were taken by Real Water. Schaefer,
Oh, you have
Hartshorn.
just, okay, hold on a second, because that's a difference of opinion. Let me give it a second. Okay, sorry, Schaefer, who?
Jasmine Schaefer, Tina Hartshorn, and Christina Sosa. They only sued Real Water in this case, so Real Water took those depositions. Myles Hunwardsen had claims against Terrible Herbst, obviously, and UNFI and other members, so one of them may have scheduled and taken the deposition. And Miriam Brody had claims against Costco, who may have scheduled and originally took her deposition, but those defendants settled, you know, they were, filed motions for good faith settlement months ago.
I'll rule in a second. I'm gonna hear Terrible Herbst. Terrible Herbst, do you have any depositions to lodge?
Just the Myles Hunwardsen ones.
So where is it?
I believe it's with UNFI, I would need to get that.
What efforts did you make to try and obtain the deposition to comply with the EDCR?
We did not make any of those efforts, no.
But was there any good cause for not complying with the plain language of the EDCR?
It was an inadvertent mistake, Your Honor. We discussed Myles Hunwardsen's deposition during the meet and confer. We had designations and they had objections, so this should not be a surprise that we would meet his deposition.
Okay, is Mr. Hunwardsen not coming in, and are you doing deposition designations?
No, he's coming in, Your Honor.
Huh, but he's on your depot designations, 18, number 18.
Yes, Your Honor, Terrible Herbst did designations from his deposition. In an abundance of caution,
Wait, Terrible Herbst?
they did page and line designations from Myles and Wharton's deposition.
They
I
don't
had the
have-
same question as you, and during the meet and confer, I said, he's gonna testify live, why are you doing page and line designations? And
But you don't have to. You can use a depot party appointment for any purpose. It's a party appointment, why would you do? Okay,
In an abundance of caution, Your Honor. I understand I can use him for any purpose, and that's why we would want to lodge his deposition. My point
but you
being-
didn't bring it.
I understand that. That's what I've acknowledged.
Right, but counsel, you understand, there's a whole plethora of appellate court cases that just say inadvertence is a good cause, right? I mean, there's certain NRCP provisions that talk about, you know what I mean, inadvertence, but that's distinct from good cause, right? In fact, there's, if you go to Severus, you know, there's other cases that talk about the idea that has to be good cause is independent. I was gonna use the Scrimer versus the Severus Sandoval example, so. Let me hear, counsels for Real Water, your position with regards to Terrible Herbst not lodging Myles Hunwardsen.
Your Honor, we hear what the court is saying, and, you know, again, it was inadvertent on their part, it was inadvertent on our part. We think there's no prejudice. We understand the language of the statute appears to be mandatory, and if there is to be some type of monetary sanction, we could certainly make a contribution in lieu of a monetary sanction to a particular charity.
Counsel for Plaintiff, your position with regards to Terrible Herbst not lodging any depositions, including Hunwardsen.
you know, they shouldn't be able to log them late and use them.
Okay. Interestingly enough, that involved in the catch-all, right, of 5 and the other sanction. Well, here's what the court's gonna do. I'm going to offer both Real Water and Terrible Herbst an opportunity if they want an order to show cause hearing regarding their noncompliance with EDCR 2.69. I'm holding that for right now because I gotta see if there's any other noncompliance issues. And instead of, well, let me see if there's any other issues. So let's walk through the rest and then we'll put a pin in that one and come back to it. So, the exhibits you all have taken care of, which was A1, 2, typed exhibit list with all stipulated exhibits marked as admitted. Electronic, was there any stipulated admitted exhibits in your groupings?
Yes, Your Honor, those are indicated on the list.
And that's in your exhibits, sorry, that's in the list that's with whom? I know you attached a partial list to your, I think it was exhibit 1, right? To your pretrial memoranda. It was-
Exhibit 1 is the joint exhibit list, and it indicates any stipulations, the exhibits that were pre-admitted, and any objections lodged.
Okay, and I have to state, TH.
Sorry, that was to indicate terrible Herbst. And,
No, those are the objection section.
yeah, terrible Herbst, that's an objection by terrible Herbst is TH. F is foundation, A is authenticity, R is relevance, H is hearsay.
How about there's a straight R without a TH? How do I know whose that is?
If it's,
Exhibit 600 PDF, it's just go one. I have to be on that page.
Your Honor, may I step out for just 2 minutes? You
Yeah,
can
sure.
continue on. Thank you, Your Honor.
Unless you're,
Mr. Parker.
okay. So the no objection stipulated, yeah. Guess you all are enjoying this, so much fun, these weeds. Okay.
if it's just
If
the,
anyone on this side needs to step out too, it's fair is fair, as long as I have one person from each side who can address these. Okay.
we indicated if it's terrible Herbst with a TH, if it's real water, RW, if it's plaintiffs, it's just R, or a joint objection.
I'm sure there's a Dakota ring for this one. Somewhere. Because, look, you have a, okay. So how about there's blank, if it's blank? If it doesn't say no objections, just blank.
There shouldn't be any blanks unless,
Council, look at your first ones.
Oh,
1 through 6.
that one's pre-admit medical records. So there's nothing in the objection column.
Stipulated to, okay, so the stipulated, okay. I'm gonna let my wonderful clerk address if there's any issues there, and I'm moving on. Jury instructions in 2 groups, the agreed upon set and the contested set, with the citations relied upon for authority. Reading straight from 2.69A3. Jury instructions from plaintiff, please.
Yes, Your Honor.
Please provide them to the marshal, and then, is yours a joint grouping, or is it just plaintiffs?
I have courtesy copies of all the groupings that we've conferred with in advance and have for the
So
court.
can we give the court a heads up? Do we have joint proposed jury instructions? Is there a grouping that is joint, such as the standard background ones, and then individual ones proposed by different parties, or is there something different?
Yes, Your Honor, we have an agreed upon set, which we agreed upon. Then we have plaintiffs' proposed special instructions, one set with citations titled cited, one set without citations titled uncited, that a defendants object to, and then there's a defendant's proposed special instructions that plaintiffs object to with citations and without citations.
Plurals on the defendants, or is there separation here between real water and terrible Herbst?
The the defendants were on the same page on all there, so it's plaintiffs that defendants object to and
Okay.
defendants that plaintiffs object to.
Okay, that's fine. Marshall, would you get those, please? Okay, proposed voir dire questions. Remember Mr. Kemp asked me that question, at least for broad categories, so we knew if there was gonna be issues or objections the court had to deal with pretrial. Do you have those as well, counsel for plaintiff?
Yes, Your Honor. Let me please,
Sure.
here's agreed upon instructions, which
Wait, Marshall, stay for a quick second. He's gonna give you,
I have copies, just
Okay.
so.
might as well stay there for a moment, because you're picking up a couple of different, no, that's for you. Please, that pile. The other 2 are for the 2 defense counsel. We're gonna get there in a second. I think Mr. Odou is gonna then give you.
I have voir dire.
voir dire. Okay, so, while Mr. Pepperman's doing that, Mr. Odou is gonna give you, on behalf of Real Water, proposed voir dire categories, correct? Is there any objections to any of your proposed categories that have been circulated to opposing counsels?
On the jury instructions, Your Honor, or the voir dire?
The voir dire.
The voir dire has just been exchanged. I have not, no, I don't believe anybody has generated objections.
Okay. Counsel for Terrible Herbst, do you have proposed voir dire?
We do, Your Honor.
Can you hand that to the marshal as well? Marshal, you're gonna take a whole pile of stuff. You might as well hang out there for a few minutes.
Yeah.
We have ours in a notebook. Do you want to pull
That's
that?
fine. We're good. It's all good. Thank you.
USB drive.
Thank you. Okay. Okay, so counsel, you've been giving you enough time to sort through your piles, or do you need another moment?
Just one more moment, Your Honor. Sorry.
Okay, got taken care of. I'm just gonna go through a couple things already taken care of, and then we'll circle back. So then sub 4 is any stipulation of admission of proposed exhibits. That's on your exhibit list. 5, the pre-screening of demonstrative or illustrative exhibits. I'm gonna pause there because I know plaintiff filed something and I have to see what defendants want in just a second. So let me let plaintiff finish their sorting.
Your Honor, our demonstratives are also in the notebook.
Oh, okay, thank you. Those have been circulated to the opposing parties to
Yes, those are
address them?
served earlier.
Okay, thanks. Counsel, you have demonstratives as well on behalf of Real Water?
Yes, Your Honor.
Okay, Marshall, will you circle back to Real Water for a quick second?
Sorry.
I'm gonna use this one for my, so what I understand is you all have handed the marshal is the proposed jury instructions in the various sets cited and uncited from all parties, as well as the proposed voir dire questions from all parties, as well as the demonstrative, at least from Terrible Herbst and Real Water, and I think I'm gonna hear from plaintiff in just a second. Is that correct?
Yes, Your Honor.
Is that correct, Counsel for Real Water?
Yes, Your Honor, I think there are some objections to some of the plaintiff's demonstratives that we have, but
Is that in a document that I have?
they have not, we just received them an hour or a couple hours before we got here, so those will be filed. I just wanted to alert the court. Or we can do them now.
Can't do them now because I haven't even.
You haven't seen them.
Yeah,
Sure.
I'm about to be handed them, I think.
We'll put our objections in writing.
Okay.
Okay. These are plaintiff's proposed voir dire topics, Your Honor.
Thank you. And are you handing the marshal also your demonstrative, proposed demonstrative?
I am looking for that right now.
That you may have. If my- I mean, we have electronically, but they're supposed to. Isn't that what you
Yes, Your Honor, and plaintiffs, a notice of potential demonstratives.
Okay, thank you. So, thank you so much, Marshall. We'll put that in our nice little magic red well. Beautiful. Okay.
There you go.
Calendar call stuff. Okay. So now let's go to the next item on the calendar call.
Your Honor, I do apologize. I wanted to alert the court that we emailed them to your JEA as requested in the instructions in the doc format, so there should be that email lodged as well, and I brought a
Okay,
thumb
thanks.
drive with, a labeled thumb drive with
Thank
everything
you.
on it as
No,
well.
no, I appreciate it. I mean, thumb drives have been very nice and helpful. The only problem is when people keep on giving us undone, you can appreciate you're not the only case. So it's very helpful when you're labeled. Thank you so very much. Okay. Okay, so. Any legal or evidentiary, I'm circling. Okay, 1 second. So we did 5 depots. Okay. Exhibits we've taken care of. Exhibit lists, you all said you did. Jury instructions, you got proposed voir dire questions. Original depositions we've addressed, but we could circle back. List of equipment needed. Does anyone need any equipment other than what you see is what you get here? We all good, plaintiff's counsel?
We are good, Your Honor.
With what you got tech support, Real Water, you good, or do you?
Yes, Your Honor, we do.
Counsel for ETT?
Yes, we're good, Your Honor.
You're good, okay. Courtesy copies of legal briefs, well, you've got some time on that, so is there any courtesy copies you have for me today? If not, stay tuned.
None from plaintiffs at this time, Your Honor.
None from Real Water this one, Your Honor.
And none from Turtle Herbst at this time, Your Honor.
Okay, you're all set with your production, your subpoenas, you're taking care of all that?
Yes.
Okay. Proposed verdict forms, I forgot to ask you about that. Thank you. Marshall, would you mind going back to counsel for plaintiff? Is there just disputed ones, or is there a joint agreed upon on verdict forms? I'm just
So-
trying to schedule for time and purposes down the road.
These are plaintiffs, there's a minor difference between plaintiffs' proposed verdict form for the compensatory phase and a separate one proposed by Terrible Herbst.
Okay. But is there anything that you all need pretrial on that, or we're good?
Well, I'm handing the marshal a copy of plaintiff's proposed verdict form for the compensatory phase,
Okay.
plaintiff's proposed verdict form for the punitive damages phase, and defendant ETT1's proposed jury verdict form for the compensatory damages phase.
Councilor Real Water, do you have any additional verdict forms, or is yours subsumed?
No, we've joined with ETT.
ETT, that was accurate, is there anything else you need on behalf of verdict forms?
Yeah, we're on the same page with Real Water, and the verdict forms and those are included in the notebook.
Okay, thank you. So Marshall, I'm gonna add to my, thanks very much. Okay,
Your Honor, one thing on the jury instructions, the agreed upon set, your instructions provided for pretrial instructions, we didn't know if that meant the admonishments or general instructions. We included them in there from the stock, but I didn't want to, make it seem like we were trying to intrude on the court's standard instructions, like don't read the newspaper, listen to the media, things like that. So they're there, but I don't.
do any of those jury instructions from any party need to be addressed as any pre-instructions other than what the court has already addressed with regards to some pre-admissions, at the time of your motions eliminate?
No, Your Honor, they're purely the admonishment instructions that.
Which some people include and some people don't.
Okay, I just wanted to make the court aware of that.
Thanks. Councilor Real Water, is there
Yeah,
anything that?
nothing to add to that.
Nothing to add.
Okay, so we're good there. Okay, so now we've gone, and you're set with all your witnesses, right? And your order of witnesses, and you're all copacetic on that, you don't need any court's assistance in that, is that correct?
None from plaintiff, Your Honor.
The order of witnesses, Your Honor?
Your order of witnesses, the fact you have witnesses, who's coming out which way, is there any witness issues that you need the court to address?
No, we've not discussed the order of witnesses. We have a listing of the witnesses. I don't know if that's the order the plaintiffs are going to call them in. That's why I was unclear with.
Sure. Well, I'm just going, is there anything you need the court assistance with witnesses? Sometimes, as you know, there's issues that somebody's tried to send a subpoena to someone, they can't find the person, or
Oh.
B, there's an issue of whether or not you're requiring all the custodians to come in with medical records, may or may not occur right now in light of certain other stipulations, you know what I mean, but versus actually just having the records through a COR, certification versus actually having the custodians appear. It's all those kind of issues that pop up with regards to witnesses. That's what I'm making sure. Is there anything pre-trial you need, counsel for Real Water?
No, Your Honor, we've worked out a lot of those issues.
Thank you. Counsel for UTT? Anything from yours?
No, Your Honor.
Okay. So now the court's gone through all the mandatory things that need to be provided with regards to the calendar call, because now I have to circle back with regards to lodging depositions. In light of the fact that there was just the one issue with regards to the depositions, the court is going to find out of the listing what's appropriate is it's going to offer both Real Water and ETT Terrible Herbst a choice. If they want an order to show cause where they can present all of their good cause for not providing said DAPOs today, then I will do an order to show cause hearing. Choice 2, as I heard counsel from Real Water was asking whether or not they could do a voluntary donation in lieu of sanctions and not be considered sanctions, and that said depositions would be lodged by tomorrow to minimize any impact, because it's not only prejudice, right, it's impact and exacerbating and multiplying the proceedings and all those kind of things that happen. So, it seems to me that those are the two appropriate choices to happen, because with regards to, like I said, the court finds dismissal too harsh, default judgment too harsh, vacating the trial date really with the impact it would have to members of the community, I do not find that that would be an appropriate remedy. So really we're looking at monetary sanctions or any other appropriate remedy or sanction. The only other appropriate remedy, I think, gives this court the opportunity to allow the opportunity for a voluntary donation in lieu of sanctions, because that would address the issue and the objection raised by plaintiff at the same time. Balances out different things. So counsel for Real Water, I'll ask you and counsel for Terrible Herbst independently. Do you wish in order to show cause hearing, so you can bring forth whatever you wish with regards to any good cause, with regards to EDCR 2.69C, or what do you request?
We would request option 2, Your Honor. The
Please.
voluntary contribution.
Okay. Counsel for Terrible Herbst, what would you like?
We would like to also make a voluntary contribution in there.
Please do so. Make sure it's done before the trial starts, okay?
Yes, Your Honor.
Depots tomorrow. Okay, so of course, comply with the mandatory language. Okay, is there going to be, I need to walk through a couple more things. We've Demonstrative exhibits, I understand that there's going to be some objections, we've got a couple of choices there. Are any of those demonstrative exhibits going to be done on opening statement? I'm trying to do a timing on when I need to hold a hearing if you all cannot work out through a meet and confer any objections to demonstrative exhibits.
Yes, Your Honors. Well, I don't know if any of the demonstratives we're gonna use for opening statements are objected to, but some of the demonstratives will be used as part of opening, yes.
Okay,
And Your Honor, Joul Odou for Blue Water, just to be clear, we provided the court with demonstratives proposed for use anytime during the trial. It appeared to us that some of the demonstratives proposed by plaintiffs were just for opening, maybe not, but I think it would be helpful to know that, you know, these are the universe of demonstratives. In terms of our objections, it's not going to be that lengthy. There's probably 4 documents that we object to. On behalf of Real Water, we think those objections could be resolved in about 15 or 20 minutes. I'm not going to speak for anybody else because I've already put my foot in that before.
I'm not, of course, okay. Counsel for Plaintiff, can you just clarify, are your demonstratives only for opening or are they for use throughout the trial? And
Throughout the trial,
okay, so that gets you that clarification. Counsel for ET&T Terrible First. This is just purely a scheduling question. I'm trying to figure out, do I need to have some time before opening? It does appear that I need to allocate some time before opening to address demonstratives, but let's hear from ET&T Terrible First.
Yeah, I think any objections can be dealt with fairly briefly, 20 to 30 minutes, I would think.
So it seems to me what we may do, I've got 2 choices for you all. Since you were going to come back tomorrow afternoon, we can do it tomorrow afternoon. If you think that's too short and you might have other things on your to-do list for tomorrow afternoon, what I can do is during your voir dire time, right, since you need it before opening, I could do it. I think we can maybe end the first day on the 16th, maybe a little bit earlier from voir dire and address any objections to demonstratives at that time, so it gives you time to do what you need to do with regards to your demonstratives except for openings.
I just knocked out tomorrow, Your Honor.
You're gonna knock it out tomorrow? Okay, let's
We
hear
have to go a
everybody.
different way, it might take a little bit of time with graphic speed.
Sure, no worries, that's one position.
Yeah, tomorrow's fine.
Tomorrow's fine, Your Honor.
Okay, so then everyone's gonna be okay that there will be just oral objections and nobody's gonna be required to do written objections to demonstratives? Would that meet the parties' needs?
Oral's fine with me, Your Honor, there's not that many on our set.
Yeah, we don't have any objections. We think it can be handled quickly, orally, but we've put our foot in it before.
No worries. Okay, counsel for ETT Terrell Herbst, do you want it in writing or is oral fine with you?
Oral is fine, Your Honor.
Okay, I'm presuming these are standard objections that are coming my way, right? So there's nothing unique?
No, it's nothing unique, Your Honor.
Okay. Counsel for Terrell Herbst, any objections? Are they just, when I use the term standard objections, I mean, I'm talking about, you know, 50s, standard evidentiary objections, is that correct?
Yes, Your Honor, Ms. Sanders.
Counsel-
Can I ask a question? The rule says something about PowerPoints. Would that include PowerPoints during opening? We're supposed to be resolving now? I didn't read it that way, but I just want to
Okay.
try to get clarification on that.
Before I segue to that, let me deal with the first demonstratives that each of the parties did present to the marshals,
Okay.
and then we'll get to your PowerPoint. Okay. With regards to those demonstratives, is there anything from plaintiff's side that other than it's going to be standard evidentiary objections? I'm going to be fine doing it verbally if it's just standard evidentiary objections. If it's going to take something that this court's going to have to research, then you can appreciate I'm going to need a little bit more time and not get.
I don't think so, Your Honor. It's pretty simple stuff.
Okay. Stay tuned. Okay, then I'm gonna be fine verbal, we'll take care of that tomorrow. Now, PowerPoints. PowerPoints oftentimes are exchanged about a day or so before opening.
Yeah, Judge, it's always been our position that PowerPoints are our work product, and so if we exchange them with counsel beforehand, they get our work product and they can adjust their opening statement accordingly. So what we've always done is lodge them immediately after the close of the argument, and that seems to have been the general practice that we've used.
Those PowerPoint, to the extent that you're using demonstratives in your PowerPoint, other than language, which might be your outlining of the case, okay? Are those demonstratives contained within the demonstratives that you provided the court today?
No, Your Honor, and a good example would be the new Wicked Witch.
See, if you'd used Mickey Mouse, you would have been fine.
I know,
As
well,
of-
I'd be fine now.
Sorry, Steamboat, as of today,
Steamboat.
Steamboat Willie, right?
Steamboat Willie, yeah. So, for example, using the Wicked Witch example again, we're gonna retool that, and we're gonna make it to the.
But that one, we already, is out there.
I know, but I'm just using that as an example,
Okay,
Your Honor.
but is that not, that's not in your demonstratives, I was just,
No,
I was just giving
that's
things.
not in the demonstratives, because that's an opening statement PowerPoint.
But I think what Mr. Pepperman said might be different than what you're saying, Mr. Kemp, in response to Mr., you weren't here when Mr. Odou asked the questions, so let me make sure we're on the same page. I thought, Mr. Odou, do you want to re-ask your question, or?
Yes, Your
I
Honor,
just want to make
so-
sure we're all on the same page.
So we had understood that demonstratives were all demonstratives to be used. We included things that were taken from a PowerPoint that may or may not be used, but we included everything. For example, we included that we might use in a PowerPoint in closing jury instructions. Typically, we talk about, the court will instruct you on X, Y, and Z, and, here's the verdict form to fill out, that kind of thing. So we included everything. And my question was, are we arguing about everything, all demonstratives to be used, including PowerPoints? Because I didn't think the PowerPoints were accepted from the court's order, so we had a different view.
Terrible Herbst, your view.
Your Honor, I interpreted it or reinterpreted it to mean graphics as opposed to simple language in a PowerPoint.
So you're the midwife, okay.
Judge, I think I'm in line with their view. It's always, my understanding has been big graphics is what I.
Okay, but, okay. Let me tell you what the court's intention is considered with the rules, is if somebody's using factual statements in a PowerPoint, an opening statement, then that need not be reviewed by the court. If, however, somebody, and I'm taking that very narrow in a factual statement, not being people using, shall we say, the LY words, right, okay? Not adverbs and exclamation point type words, right, okay? Because it's the type of things that doesn't draw an objection, okay? If it's animations, now I have to add an AI type, issues, cartoons, pictures, depictions, right, to which there may be an objection on how it's portraying something, whether it's proper opening statement because of a factual basis. Those the court does find need to be exchanged because realistically, once you do it, you're risking a potential mistrial in opening statement, okay? So whether that's contained within the graphics comment of counsel for AT&T Terrible Herbst, whether that's broader or narrower, that's really where the court is. So Wicked Witch would have to be reviewed because you have to see if they're going to do, because if you hypothetically did the Wicked Witch with one of their client representatives' face, right? That's what I'm giving as a hypothetical, but you understand why I'm saying this, okay? That would be something that would be appropriate for the court to address pre it being shown to the jury, because some people may say that that's the bell that cannot be unrung. I'm not saying whether it is or isn't. I do not advise your opinion, but you understand, it's those type of things. If it's something like report X says ABC, and you're directly quoting from a report X ABC, right, and it's not subject to some motion limiting precluding it, then I don't see that that is an issue, right, because that's something that's appropriate for opening, you know what I mean, it's the interpretive things. So where this court would go with it is erring on, it's not even erring. Court would see that the rules talk about, because it does talk about D5, right? Okay? At the calendar call, the court may schedule a conference to be held prior to the commencement of trial which the following issues are resolved. That's under subpart D. And subpart 5 of D says the pre-screening of any demonstrative or illustrative exhibits to be used with the jury. And it says any, it says demonstrative and illustrative, okay? So this court's interpretation of that rule based on other case law, right, and I'm spacing on the name exactly, but it's the case in a criminal context where they put guilty underneath the person's face and it came up during the opening statement, okay? That would be illustrative, demonstrative, right? We avoid those type of things, which is why I gave the example of the Wicked Witch happened to have the face of one of the defendants or their counsel, right? Okay, you avoid those things. So, in light of that, yes, I need to address purely consistent with D5, 2.69D5. Now, I think that means real water, you think you've put that all forward, and maybe even more. Terrible Herbst, I'm not sure your position in plaintiff, I think you might have a little bit of a different position. So, I think the better way to do this is tomorrow to let you all substantively address your position on what should or should not be part of D5, and then the court to address D5. And to the extent that there may be some demonstrative or illustrative that have not yet been provided to the court, you bring them. Are we talking anything more than we could wait to counsel for plaintiff?
Well, Your Honor, I've got to go back through the Gallagher trial because we do use a lot of stuff in the opening and closing, and I'm not, but they have all this.
You understand, I don't think people have used Matchbox cars crashing into each
Right.
other with the comic crash on it, okay? Of course, the court's gonna have to review that okay?
Right.
I'm not taking a position, that's not any particular case that was ever before me, I've heard about it, okay? So, you know what I mean? Kapows, if you all use comic book.
A Gambit toy is a good one. You pull the toy out and the whole thing collapses. That's a real good one.
I'm
Not
just
in
saying.
this case,
Right, and you understand, those type of
Right.
things need to be addressed pre-trial because those present challenges in front of a jury for addressing.
Right.
So that's why I'm wondering, is tomorrow give everybody enough time to, the court to be able to address what you think you're going to do? Or do I need to reserve time instead during your voir dire, maybe the first day of voir dire, stop it, let the jury go out a little bit earlier, and have it at the end of day for you all, so you've got some time to coordinate, meet and confer, and see what you actually need the court to address after you've actually seen
the first day of voir dire would be better for us, Your Honor.
counsels for defendants.
Joul will do for real water, we have no preference. We're coming back here tomorrow or go.
We may not need to come back tomorrow, that's why I'm,
Yeah, if we're gonna move everything, we would prefer to have it all probably during voir dire, because then tomorrow we can work on what we need to work on for trial.
okay, counsel for Terrible Herbst.
Yeah, I'd agree. It sounds like we haven't seen everything yet, so if we could
It
have.
seems to me that you all just got some stuff just now, and you may have gotten, maybe getting some other stuff, so, voir dire, okay, so on the 16th, we'll let the jury go a little bit later, we'll find a good time for whoever's in the midst of their voir dire at that time, and probably stop around 4 o'clock, so that I can address 4 to 4:15, so I can address demonstratives. Does that meet everybody's needs?
Yes, Your Honor.
Yes, Your Honor.
Counsels, yes, plaintiffs? That was for you too? Okay, perfect, we got that taken care of. Okay, are you all gonna have any objections to jurors asking the questions under Flores versus State? This court always allows it, we just have a process that it needs to be done.
No objection,
We
John.
have no objection.
No objection from real water, Your Honor. Obviously, we would anticipate that if there was a jury question, it would be distributed to the parties, we would have an opportunity to look at the question and see if we have an objection to the particular question, and then if we needed to make a record, we would go off and make a record, since we can't do it at bench. So, in other words, if the juror asked something impermissible for whatever reason, and there was a disagreement as to whether the question was impermissible, we need a record, we would have to take a break.
Let me explain what, you said partly with, let me go with the court's normal process, I'll explain that, and then we'll see if we wanna do it a different way, which is okay. Counsel for Terrible Herbst. The first question I'm really asking is, are you going to raise an objection? Nevada allows jurors to ask questions. There's a process by which they normally ask questions, and then there's some varying process on how we decide whether or not those questions actually get asked to the witness.
So no objection to the first question?
And process you wanna hear about? Is that
Yes,
right? Okay,
please.
that's fine. So there being no objections, jurors, well, the question really becomes the process. So let's walk through real briefly the process, because we're getting towards the end of the day. Okay. The court's general standard process is as follows. I explain to the jurors at the beginning, when I give the introductory remarks, when we walk through, we talk about questions coming from the counsel, et cetera, and that, you know, they don't take the fact that who the question's coming from makes a difference, and we walk through juror questions. And then I tell the jurors, in fact, please don't take offense, because I'm gonna tell you right now, there's gonna be some juror questions that you may wanna ask, and they can't get asked, and I'm gonna tell you in advance that some of them won't get asked. Please don't get offended on who's gets answered and not get answered, okay? Then I walk through the process with regards to how to ask a juror question. The way I tell them to ask a juror questions, to use the entire sheet of paper, to put their badge number, the last 3 digits of the badge number at the top, their last name, and then please write as clearly as possible what the actual question is. If there's more than one question, to please number it like 1, 2, 3, okay? Don't just bundle them all in. And then the next step is gonna depend on how you all want from a process. So I explained that to the jurors, like I said, and I explained to them that the juror questions need to be asked while the witness is still on the stand, that they can't say, guess what, we had a witness 2 days ago, we now want to ask that person a question. It has to be asked while they're on the stand, and at the end of the counsel's questions is when any juror questions happen, okay? And I ask them usually to put them nicely on that nice little bar there, and the marshal takes them at appropriate times, and we put numbers on them based on the order in which they ask the questions, okay? The general process this court has utilized, which is subject to change if you all want something different, is usually people do ask me to do this at bench, okay? And so what we normally have done in the past is we put like a little number on it. I actually really just oftentimes use a Post-it, plaintiff, defendant, if there's a third party, right? And I have you all put okay or no, right, on the juror questions. In this case, if there were 3 okays, then it gets asked. If there was an okay, if there was any no, then we hear the argument on that, and the court makes a ruling, decide to ask or not. Most parties have always asked me to do those at bench. A few times they've asked those to be done outside the presence of the jury and have the jury take a break. I will tell you the court's fine either way, okay? We just need to know in advance so we don't start that one way or another. And then the questions that do get asked. The court's general process thereafter, and I tell the jury, is that if there are juror questions, then oftentimes I will allow counsel a question or two specific to that juror question if they wish to do a follow-up. For example, if there was a question, hypothetically on, take something totally out of this, on a real estate appraiser, right? As to explain the different types of real estate appraising, right, that they did. Which one did they use if they were unclear, okay? If they used, a rent space to the various aspects with a juror, with appraisal of the house, okay, for a property. Example. Then if counsel had a specific question as a follow-up to that, would it make a difference if you use the appraisal guidelines of 2020 versus the appraisal guidelines of 2023, okay? I'm picking a crazy hypothetical. Actually, not crazy, but it's just hypothetical, okay? That would be an appropriate follow-up question, but that would not be an appropriate follow-up question if somebody wanted to then go, oh, well, in light of your answer, if then creating some kind of new hypothetical, right, that had nothing to do with the question, okay? And then people still have the objections, but usually allow a couple follow-up questions. Oftentimes counsel don't have follow-up questions, sometimes they do. That's the court's general process. So counsel, Mr. Odou, let me hear what process you're requesting, and let me see if everybody's agreeing with a different process, because the court's open to other processes as long as we get everything taken care of. Go ahead, please.
Your Honor, that sounds completely acceptable. Last time we were able to quickly reach agreement, some questions to be asked or not asked. So the okay or no on a Post-it works just fine.
And then it becomes part of the court's exhibit, right? Each question is, so I give the court 2 powers. The only difference, I think, between what I said and what you said is that oftentimes the parties have wanted just the discussion to be quickly at bench about whether the question get asked, in my example, if there was a no, versus you saying you wanted it on the record at counsel table. So which one are you requesting for this case? Let me hear everybody else's viewpoint afterwards.
Yes, Your Honor. So if there was something in particular that we felt we needed to make a record on, then we would definitely ask to, take a break and make a record on it. I can't imagine that could happen, but I can't foreclose that possibility either.
So would you like it to be question by question, or witness by witness, so that you just set forth?
It would just depend on the circumstance. So if in your real estate appraiser example, maybe there's 3 questions from the jury, we reach a quick agreement amongst the parties, there's no need to go off the record. We can hand it back to the marshal, hand it back to the court can ask the question. It could be that, we can't decipher the person's handwriting, we may need to take a break just to do that.
I usually have you come to bench and I hand you the actual question, so that each person gets a chance to read it, and I usually try and take turns so that one person doesn't feel like I've handed them first each time, right?
Right.
So whoever the main counsel is, right, is scrunching around the front of the thing, okay? Other people, we just ask you to speak quietly, we ask the white noise, and if anyone can hear us, we ask the juries to tell us to raise their hands. So you want to leave the option open that if there's a particular question that you put, or anybody's putting no on, that you have to request at that juncture, Your Honor, can we go on the record and address this?
Yeah, if there's something really unusual that we would need to go off on the record on, then that's what we want to be able to do. Like I said, I can't imagine such a circumstance, because typically if the question is obviously out of bounds, you know, the juror wants to know about insurance, and we all go, yeah, they can't ask that. That's an easy one.
Most of the time, seatbelt, not always, but okay. Okay, so you bring it to the court's attention if it's the kind of question that you do not want any discussion at bench, that you want to have it outside the presence of the jury? Is that what you'd like?
If it's really unusual, yeah. We just want to be able to have that option. And again, I can't see that happening, but certainly we don't want to be foreclosed from preserving a record for appeal if there was something really strange.
And are you amenable to the idea that parties can ask a few follow-up questions?
Yeah, we're fine with that, Your Honor.
Okay. Carol Herbst, CTT, your position, please.
I would be agreeable or minimal to allowing counsel to at least first ask some follow-up questions to address any of the juror questions that they may have, and would prefer we do it at bench. Sure.
Yeah, you got real comfortable leaning back, we couldn't hear you with it, okay. Are you okay with Mr. Odou's position?
Yeah,
That to
yeah, that's
reserve
fine.
if somebody wants something on the record, that they then tell the court before there's any argument on that?
Yes, Your Honor, that's fine.
Okay, counsel for plaintiffs, go ahead,
We're in
please.
agreement with Mr. Odou's position.
Okay,
Here we go.
boom, taken care of. That takes care of juror questions, and you're okay with juror questions. Is anyone wanting juror notebooks? Nobody's asked me that in years. I should say there's maybe been one in the last, decade. Anybody need juror notebooks for this case?
No, Your Honor, not for plaintiffs.
Not for raw water, Your Honor.
Not from Terrible Herbst.
Taken, done, taken care of. Okay, what other issues would you like to discuss at your calendar call that the court has not already addressed that we can assist you with?
Your Honor, just two minor issues,
Your
more.
Mariah Witt question. I just found my to-do list. Go ahead, please.
More for your clerk, Your Honor. We have some physical evidence that was admitted in Gallagher, the titanium tubes and a stand and
Jug of water.
no, those are demonstratives. There's one more I forget, but I just want to know what we need to do to transfer those.
What you're saying, they're
exhibit-
currently in the vault?
Yes, they were admitted in Gallagher and they're in the evidence vault.
Did you guys want a photo instead of using the actual items or something?
No,
Didn't
we'd rather
someone
have the
talk?
actual items, Your Honor. Usually we have to do an order that transfers from one department to another,
Yeah.
because the other department is supposed to keep them in their possession for purposes of appeal.
Yeah, so you're all gonna provide the court a proposed stipulation of what you're requesting with
Let's
regards?
draft up- If that's okay with you, Your Honor, we'll work out a stick with,
Does that meet everybody's needs?
Yes, Your Honor, real water's in agreement on that.
Okay. So what we're gonna do is, just in case there's been some change that I'm not aware of, because 2024 is a new year and there's always things changing, I'm gonna ask my wonderful clerk to send an email to the vault that if the parties to a stipulation, the court signs an order to be able to get these physical items that were in Gallagher. And do you want to just quickly describe them, so it's in her email, so you can just say it's titanium,
there's titanium tubes,
okay?
and then there's a stand that the titanium tubes were placed on, kind of with a V thing. Those are, I think those are the two things, really.
Yeah, the third might have been the meter, which we weren't asking to.
Yeah, there's a meter too, but we don't need that.
Do we need a meter?
We do not need that. Judge, usually when we prepare the stick, we've had the judges for both departments sign it.
Pardon?
We have both judges sign it. The department we're taking it from and the department we're moving it to, just so they're informed.
Perfect. Right, still would bear the, and
Of course, you know, when I think about that, we have parties in the other case that we have to suck into this. We should at least notice the parties in the other case.
yeah, can you put the parties, you can send an email, right, you can serve your proposed stipulation on all parties in Gallagher and all parties, because I don't think I have all my NEOs yet in this case, which is where I was gonna go at the very end of this for you all. It's not you all's job, but to the extent somebody wants to double check to make sure your caption is correct and we got your
Right.
NEOs, somebody, because then you do that before trial, right?
Yeah,
To make sure we've got the right parties. It seems to me if you notice everyone who's not done an NEO out of this case, right, as well as all the parties in Gallagher, that you're wanting to do that, and then you have 2 signature lines for Judge Williams and myself with your request, that should, it's gonna meet my needs, and unless somebody tells me it can't meet my needs, then I'll have to readdress it, but that should meet this court's needs.
And Your Honor, for the record, it is 3 items. It's there are 2 titanium tubes. We have them listed as separate exhibits in this case. I can't recall if they were separate exhibits in the Gallagher case, but we'll identify the exhibit numbers that they were in Gallagher and the exhibit numbers they are in this case as part of the stipulation in order. And if there's any additional information that the vault requires for us to effectuate the transfer, we'll use it. And then the third is the metal rack that was used. So 3 items.
Wasn't there, Your Honor, Joul on behalf of the water, I think we also had requested the concentrate jug and then the water bottles. I don't know if those were included in one.
I don't know that we need to transfer those, do you?
You don't want the concentrate?
We have it.
We have no.
Oh, you have another one? Okay, I got another one.
Are you okay with,
And we're okay with that, using a different one. We have quite a few bottles of water, as the court could imagine, so you have plenty to choose from.
So the 3 exhibits are 252.
are you
Oh, I'm
citing
sorry.
from this one or from Gallagher?
The 3 exhibits in this case are exhibit 253, titanium tube used in production of concentrate 1 of 2. Exhibit 254, titanium tube used in production of concentrate 2 of 2. And exhibit 255, metal rack used in production of concentrate.
Okay. So, anything else from plaintiffs?
One last thing from plaintiffs, Your Honor. Previously, we discussed a caption for the trial that just included the parties to the trial. Even though we've settled with all the other defendants, the settlements have not fully been effectuated, so that some of the defendants have not yet been formally dismissed from the case. And so we were a little concerned about amending the caption to exclude parties who have not yet been dismissed.
Hence my comment about that you all might want to check with some of your colleagues, although it's not your obligation, to see where I really have dismissals and NEOs, right? You're talking about, there shouldn't be any parties other than, you don't have any I don't have like an opioid issue where I have bankrupt parties that are staying.
No, Your Honor, they've
It's just a matter of
been-
people haven't gotten their orders in.
all the motions have been approved, motions for good faith settlement have been granted, and I believe all the orders have been in. But they haven't been formally dismissed pursuant to a stipend order to dismiss them from the action.
Because there's pending things going on behind the scenes that you all are still taking care of.
They haven't paid us.
Yeah, they haven't.
Pending issues behind the scenes that you all are taking care of?
Yes, Your
Correct.
Honor. So, my
Okay,
proposed remedy was to stipulate to the caption to use for
For
purposes of trial.
it's competent to stipend order.
Okay.
Does that mean everybody's needs, so what you're just gonna say is, you'll just say, look, there's some pending parties that good faith have been granted but don't yet have stips to dismiss for whatever variety of reasons. The parties agree that this is the caption that the court should read in front of the jury?
Yes, Your Honor.
Okay. Now, here's gonna be your challenge. That's, Mr. Kemp's about to ask, here, when I was starting the challenge, Mr. Kemp, I think, and I are gonna be on the same page on.
Should be played outside as well.
Played outside is the problem, yeah. Therein lies a, let me figure that one out. Because therein lies a challenge, because they go straight off the official Odyssey record. You're not asking to change the official Odyssey record, you're asking to present something to the jury. Because if I do it in the official Odyssey record, it will show them as dismissed, which is maybe not what plaintiffs want if you're still working on things behind the scenes. So let me, sorry, do you have a suggestion? If you have a suggestion that works, let me know.
Judge, we were thinking maybe we could just dismiss everybody even though they haven't fully satisfied their obligations under the settlement agreements with a savings clause saying that if need be, we can bring them
Let
back
me
in.
see if there's a way that we can work it. I just don't know from an IT standpoint. Let me see on our end, I'll put that on my
Okay.
question list to see if we can do it that way without you having to do dismissal. If not, is there any objection to the court doing that?
Real Water has no position on this, Your Honor.
No objection, Your Honor.
Okay. Yeah, let me see, because what they may be able to do, would you all be? Versus, okay. Let me find out from IT, I don't think that's can you find out if that's a clerk's issue for the captioning that gets done in the lobby? Is that a clerk's issue or an IT's issue for the title of the case and the parties of the case? Would you mind asking? Sure. And CC me, because then I'll send it to Mike Dunn. That way, I'll find out if it's IT. Okay, that's on yours question list. Everybody now exhausted everything from plaintiff? Should I
Yes,
move
Your
on?
Honor, thank you
Okay.
very much.
Councilor Real-Water.
Your Honor, just very briefly, it sounds like we are not coming back tomorrow, that we are going to handle all of the remaining issues on the 16th. Just wanted to confirm.
Let me make sure what we're talking about remaining issues, because I'm going to do this. You're welcome to come back tomorrow. I've blocked out time if you want it. I have other things to do if you don't. But the remaining issue I see is the demonstrative exhibit issue, which we said we're gonna allocate on the 16th in the afternoon.
Yes.
And getting the depots here is not anything you need court time for. It's just get them here, please, and put them in the inbox.
Yes, Your Honor.
On the
With re-
demonstratives, we need a drop dead date though, because, it wouldn't be fair just for everybody to throw it all at each other that day.
Well, what I understand is two of the parties say that they've given everything to plaintiff, that it's just plaintiff, and so we'll get a date.
Okay.
Okay,
Give
well-
me a drop dead date.
Sure.
Okay.
Next Tuesday with everything else?
Sure.
Right, that's some other stuff on Tuesday. I'm just trying not to give you a whole bunch of, you asked for Fridays on your outstanding orders.
Yeah.
So if I just put everything to next Tuesday, does that work? So you've got your outstanding orders by next Tuesday, or do you want it left at this Friday?
Tuesdays would be fine with the outstanding orders too, Your Honor.
I figured you might like some extra time. Does
Yeah,
that work for
sure.
everybody else?
Yes, Your Honor.
Yes, Your Honor.
Okay, so you've got that for Tuesday, you've got the demonstratives, any demonstratives that have not already been exchanged, need to do it. And Tuesday is also the day for any blanks, remember, in your objection charts. Okay, so those I all see are council-driven that date. That then triggers for the court on the 16th to address demonstrative, because it gives you a chance to do your meet and confer after you make sure you've exchanged everything, to see what actual issues you need the court to address on the 16th. As far as the issues with regards to some of the exclusion of the testimony, for example, I'll just say, you all call them customer complaints, so I'm gonna use that phrasing, right? It seems to me that is best once you have your order of witnesses, that we reserve some time before that witness is set to testify, that you need to let the court know to see what actually is the outstanding issue that was deferred by the court, right? Because
Yes.
that doesn't make, Mr. Parker, you weren't here for some of this, so you may not.
Yeah, that
you
last
don't
comment
need
struck
every-
me as
There was a
odd.
long discussion on that. I'm not rewinding on that one.
Okay.
Can you ask one of your colleagues, there's an issue on the depot designations before you got here?
Oh, no, that's not what I was concerned about. I was concerned about the last comment you made. in terms
Because
of-
that ties to that, and it ties to the
does.
motion eliminate, and so we're just leaving that to you all to find a way, and to the extent there are things like motion eliminate number 9, et cetera, that you've got to tell the court enough time before the witness, not the day the witness is gonna testify, right? But enough time that we can schedule some time if there's an outstanding issue about the breadth and scope, whether it be live or whether it be via deposition, right? So I can address that. So that I don't see as something that's a tomorrow issue because you're not there yet. And nobody needs me to rewind the scope and breadth of that, right?
Yes, sir. Do not need to do one
You don't need the first 45 minutes issue, no.
No.
Okay, it's a few minutes before 5. So I don't see you have a date there that needs to be done. I'm gonna ask you in just a second, we've got another media request which I'm gonna ask you about, so that's gonna take care of in just a second. But I don't see that you're asking for, I don't have to get, since there's no pre-instructions on the jury instructions, those are appropriate time of trial, same as the verdict. Exhibits get handled at the time exhibits get introduced. Nobody's told me that there's any need to do something pre-trial on any exhibit that hasn't already been taken care of with regards to motions and limine, et cetera, and other pre-trial motions. So I don't see at this the jury answer to Mr. Pepperman's question with regards to juror number. That's just giving you an answer. So when we get it, we'll forward it to you. The other jurors' excusals we'll get into. You all provide those and we get those taken care of for you. That's not time. So I'm not seeing that there's anything else deferred from the court standpoint other than what I just have specifically articulated in the last 4 or 5 minutes. Mr. Odou, am I missing something?
No, Your Honor. I think that is everything that we've talked about today. Mr. Pepperman and I are still attempting to work out real water motion limine number 11.
And I believe there's also some motion, some discussion you all, and I don't need to tell me now, but you all made a reference to there may be a Brody stipulation heading my way. I just need to know if it's actually gonna head my way, but I just need to know about it before I have to rule on anything, right? So.
We circulated it, Your Honor. Actually, Ms. Fresh sent it around. I found one small issue, a grammatical issue. She said she's have it corrected and sent back. It's almost identical to the one we already have approved with the court.
Okay, so does that mean that there's, remember from the courts, I just need to have a knowledge base about whether or not it's been liability for all plaintiffs.
And causation.
It wasn't causation, carve out for Brody causation. Is it now Brody's included in the causation?
Yes, Your Honor.
Okay. Brody does not impact terrible Herbst, correct?
That's correct, Your Honor.
Okay. Where I'm just going is in light of their stipulations, is there anything else the court needs to address for purposes of terrible Herbst?
No, Your Honor.
Only the Hunwardsen, which I've already addressed. Okay. That's where I'm just making sure. So that's where this court's at. If there's something that I've not yet addressed that you think needs to be addressed, Mr. Odou, I'll let you go, and then I'll have counsel for
Nothing further from real water, Your Honor.
terrible Herbst.
Nothing further from terrible hope, Your Honor.
Okay. 5 o'clock. Last thing is, David Siegel of the Court View Network has made a request. They haven't said for how long.
Is that the courtroom view network, Your Honor?
Yeah, it's the
Yeah.
one they usually bring the little small camera.
I'm familiar with them, Your Honor.
Anybody
I
have
have no
a view?
objection, Your
No
Honor.
objection, Your Honor.
No objection, Your Honor.
They can't be here during voir dire.
Right.
They can't be during here voir dire, or if there's something that you all tell me you want closed. But at this juncture, is there any reason not to sign it?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Okay, then I'll sign it. And they've got the same things, and they're just gonna have to work out the feeds with regards to you all's tech people, so they're not interfering with what you all need. But you worked enough with them that you've got that taken care of, right? 5 o'clock, boom, have a great evening. So then I will not see you all tomorrow, right? Does anyone need the court's assistance tomorrow? Counsel for plaintiffs,
No, Your Honor.
counsel for real water,
No, Your Honor.
counsel for terrible Herbst.
No, Your Honor.
Thank you, have a good one. Ed?
Off, Judge?
Off.